for orders. I have filed one IA. The state,
Matter of which year?
but year issued.
Which year, sir?
2025.
25.
Yes.
Notice has not been issued.
Notice was issued, my lord. There is no stay of that proceeding, my lord.
What is the nature of proceeding?
DB case, my lord. DB case.
DB case.
Yes.
Who are seeking transfer?
Husband, my lord.
Why?
Raul
DB case, where is the jurisdiction to seek transfer? Which provision? The strategy of disturbing the cases, dislocating and disturbing, involving the High Court should stop. Since you are a young counsel, you should learn this. And definitely I'll allow the memo. I have a purpose in telling you.
that
You are not present of the person. The concern expressed by Supreme Court, High Court, that cases have been kept pending.
yes, ma'am.
And you are involving the High Court in this. And day in, day out, we are directing the court to dispose of the matters. Since when the DV case is pending?
No, case 24.
Since for 2 years it is pending. Why? Because you have filed here. You must be showing that that High Court has interfered.
There is no
You must understand these are urgent and bail applications. Because bail application, somebody's food, clothing, medical, everything is taken care of by the state.
correct.
And here, you are just, as a matter of strategy, the High Court is involved and that order is shown that yes, notice has been issued. Order se anantu. Apna proceeding answer deleni tapare. Has the proceeding proceeded after you filed TRPC since 25?
Proceeding charges.
Then why you are seeking transfer?
In between, compromise.
Compromise in DV case, what sort of compromise? What for financial assistance?
Maybe
You will give the money.
last date, madam, my lord, she compromise.
Compromise capacity in a DV case.
No.
If the financial assistance is sought for a day, it is a ameliorative provision. You will give the money or I will give the money. Can I direct? If I say transfer that I give the money, or say legal advice will give the money. This process actually is not working actually correctly. Anyway, ଷୋହଳରେ ଆସିବେ ନା କେବେ ଚାହୁଁଛନ୍ତି ଆପଣ?
Tomorrow, any day.
ତୁମର ହେଇପାରିବ ନା ସେମିତି କଣ ଆପଣ 25 ବର୍ଷରେ କେସ୍ କରି ରଖିଥିବେ ହଠାତ୍ ତୁମର କହିବେ
16.
16 କେତେ କହୁଛନ୍ତି? 16/3 ଆଜି କେତେ? ନେକ୍ସଟ ୱିକ୍ କହୁଛନ୍ତି ତ ଠିକ ଅଛି।
Pardon to make a mention, Your Lordship.
Give your demo.
Writ petition regarding OPDR matter, Your Lordship. The certificate proceeding initiated in the year of 1955, and it is still pending, Your Lordship.
Fresh matter?
No, Your Lordship. It is on the verge of its hearing. The court has granted 3 to 4 times of time to file the written notes of submission to the state. As the last chance, the court granted
So this
time.
is for after notice.
Yes, Your Lordship.
After notice, why it's a pending? So every after notice matter cannot be taken up. It will be listed, but you must understand the limitation, capacity rather. After notice, yes, please give your name.
Your Lordship, in this instant matter, what has happened is this is a land acquisition appeal. We had filed an IA for the exemption of court fees till the disposal of the case. Your Lordship was gracious enough to accept that IA and dispose of the IA. But Your Lordship, what has happened is erroneously all the land acquisition appeal has been disposed of. Your Lordship, I have also brought
Disposed of by me.
No, Your Lordship. It is disposed of erroneously by the registry, maybe. Your Lordship has only disposed of the IA.
Order said as you. The order said. We commencing take soda taste for them to. Yes.
Much obliged.
30 भी हो कौन तो बोटा कर पड़े
Page 1 to 5
6.
पांच पेज वाइज जीवा पेज वाइज
next
Item number 7 and 8.
अरे पांच है 1 रू 5 है 1 रू 5 आ गया
page 2 6 to 18
Item 6.
हाँ
I create for
What is your instruction?
No instruction, my lord. But I have contacted, giving message to protect adjournment.
When you want, we'll pass the order. When do you want? आपण तारीख केवे सजेस्ट करछो?
1 week after.
डेट करंतु 6टा.
33.
We commencing 30/3/26. Yes.
We would say some kind
Two documents?
I don't know what to.
टू डकायनी मैडम टू टार आपनकर जोटा स्पेसिफिक लिस्ट हेची ताको अर्जन करंतुनी एटा कोन कंपटीशन चलची कि अब हाई कोर्ट लिस्ट करबे आपण अर्जनमेंट करिवे सो प्लीज वेट डोंट बी इम्पेशेंट
7
अच्छी टाइम अच्छी बस तो
Item of 7 and 8. Pray for adjournment.
ଆପଣଙ୍କ ନାଁ
Escape.
ମହାନ୍ତି ପାୱାର ଅଛି ଏଇଟା ଆର୍ଜନ କରିହେବନି dismissed. I am not at your beck or call that 4 times I will hear the matter and then I will allow adjourn. Dismissed.
Senior is not available.
I am available. But dismissal senior is not necessary. Judge is necessary and court is necessary. Court is not here to entertain adjournments for 4-5 times. That creates a very bad impression. We are in public gauge. And after taking dates, you will blame the system that the matter is not getting disposed of. You consult your senior. Dismiss for non-prosecution because of repeated adjournments.
Right. Item 14, ma'am.
If it is a battle of wits, most of the time I will win. Please appreciate. And fresh matters, they are taken up, listed for to be adjourned. Kebe ଚାହୁଁଛନ୍ତି?
2 weeks.
Busy counsel doesn't mean that the court will wait and adjourn the matter. Which provision? Constitution, CRPC, CPC. Which provision? The 8 cannot be adjourned for 2 weeks. 8 kebe instruction नियंतु. Consult your busy senior. Or he will not listen to you. He is so busy. Talk to your busy senior and get item 8 kebe आनिबे. Who does not busy senior के साथ कथा होता. अपन कैसे responsibility नोचन? If it is your strategy, you have fallen flat on your face. By taking name of your senior, that is a strategy for you. After so much of years of practice, then you have fallen flat on your face. That strategy has not worked. If it is correct, then the senior did not instruct you to say this. That I am busy, I will not appear before the court. Where he is?
Not Puri.
Huh?
Puri.
So High Court is not a good place.
Yes, ma'am.
Then
My lord,
it will be reflected in the order sheet
my lord, day after.
that your senior is busy at Puri and adjourning the matter.
My lord, day after.
So they are not at your choice, sir. Upon this kuchandi ki day after tomorrow kuchandi. Today is the best day. Fresh matter fere. The effort of listing matters tale labho kon hela. Seven ta ketbe rakhibe?
33.
30. What है
Next.
Next week क्या रखिए? तक डेट दी. I का next week छोड़ो.
33.
CBC 30 ने रखो. But if you want whatever you address, exactly verbatim reproduced in the order sheet.
Yes.
And also my observation that repeated adjournments, the counsel is busy at Puri. Yes.
Item.
And 8 I will not adjourn because I am not here to hear once, twice, 4 times. Yes, please.
In my lord.
Yes, please.
I have no instruction, madam.
କାଗଜ ଦିଅନ୍ତୁ ମାନେ ଯେତେବେଳେ ଆପଣ ଏଟା ମେମୋ ଦଉଛନ୍ତି
Yes, madam.
ରେଜିଷ୍ଟର୍ଡ ଲେଟର
Yes, madam.
they will turn around because at times the lawyer's job is a thankless job. They will not listen to you, but they will blame you.
I have instructed, but they.
Send a registered letter. Leave it there. Coming from that side, at least we have some idea about what is how they deal with the lawyer. Yes, next. Ko jayenge Mr. Bhuya 14, 15 to 18, then 19 to 25,
25.
19.
In item 19, Jagannath, he is the conducting counsel is the matter.
अरे ऑर्डर्स मैटर आपण करिवे आपण यदि ऑर्डर से डिले कंडोनेशन भी करिवेनी and that before a court no matter adverse order is passed if it is heard finally heard you decided you may challenge you should challenge
So only you only request him to get he had some personal difficulties.
but why sir for orders matter that I'll record
I have no power.
you may not have power you have become powerless what is your name powerless
Devasis
Devasis
Patri.
I'll record that orders matter don't this you should not mention first of all orders matter then why it is listed for orders
I don't want
order will be passed it will be recorded yes केबे चाहउछंती
Then
केबे चाहउछंती केबे से कोन हेछि केबे
1 week after.
आगे
1 week after.
डेट करंतु 19 टा
receive.
yes तापरे
I don't 22 for a vote.
sir kindly file memo sir
Yes.
एरा कोन इन्फ्रुक्चुअस काहे की हेगला इन्फ्रुक्चुअस काहे की हेगला
सर साक्षी शेष हो गोटे दुटा साक्षी सरव तो
सेटा जत प्रथम मो कहउतली मिस्टर महांती को कोन हसिले आपण नागड से कटक anyway yes 23 ରୁ 25
Item 25.
25
25 for the petitioner when non senior for the
I am appearing for the opposite
yes,
party.
Mr. Rautra has been engaged in this matter. Today has been badly placed. Only I accorded today, my lord.
you talk to your senior I mean
Yes,
well,
I have
serious objection.
not me
I have serious objection
not
because I succeeded in the tribunal.
yes, yes. In the
Although I
meantime,
succeeded
in the meantime, both have
order.
It is
Which
to
was I am not giving the financial benefit.
yes, it is finally hard. Only I
If your lordship want to adjourn, then your lordship adjourn this matter as a last chance.
yes, yes.
No further adjournment will be
next date.
granted.
look but date करंतु I'll record you sir.
Yes.
we commencing 6 4
The interim order also interim to control. Tell them.
Rautra should I record Mr. Rautra has been engaged
Yes, yes. Already
recently.
his name is there.
no seta kebe seta because that if I into 2019 I recorded in 26 that he has been engaged
No, he has been already engaged. Today has some badly.
Acha, he's already
Yes.
there around so that is not I hope you understand what I'm saying
Yes.
don't make my orders laughing stock yes next
Actually, interim order.
interim order yes I have noted I'll pass the order
Well, go ahead.
I have to record Mr. Swai's objection that's a judicial order.
31.
କିଛି ହେଇପାରିବନି ମାନେ 22 ମିନିଟ ମ୍ୟାଟର କଣ ଷ୍ଟେ ହେଇକି ଅଛି ଷ୍ଟେ ଏକ୍ସଟେଣ୍ଡ ହବନି ଆପଣ you are involving the High Court in keeping the maintenance matters pending before the trial court by filing TRPC and RPFF. What is the condition granted? Technical stay ହେଇକି ରହିଛି ଆପଣଙ୍କ ନାଁ କମଳାକାନ୍ତ ସେଠୀ I'll pass that order that you have to secure the decree. Supreme Court has observed that the non-application on the part of the non-application of mind of the High Court. If I go repeatedly do not apply my mind, then I do not know what stricture I will invite. Not in case of me, but you should not be involved in these kind of. These kind of cases are actually it's not in the interest of justice. And every lawyer who is asked that what is the instruction regarding securing decree, he falls in, no instruction. And as if a most difficult question is asked on jurisprudence. And this is the simplest of principles. You get a stay and secure the decree and get a stay. After the stay is granted, for 4 years the matter is kept pending.
So 1 week lives.
1 week କଥା ନାହିଁ ଆପଣ ପଇସାଟା ଦିଅନ୍ତୁ ଆଜ୍ଞା 1 week ମୁଁ ମାଗୁନି ଆପଣ 1 week ଦିଅନ୍ତୁ ସେଥିରେ କ'ଣ ଅଛି କି 4 years ହେଲାଣି it is not my assignment for the last 4 years. My assignment is for last 2 months, 1 month or 2 months. I'm not worried that the matter is kept pending by you. I have not kept the matter pending. Taking blame is another thing. That's a different thing. But I'm clear in my mind that I have not contributed. When you will deposit the amount,
Take instructions.
that's while accepting the brief, take that instruction. You must treat yourself with some respect. You are not here to bargain decrees passed by courts. And so stringent orders have been passed by Supreme Court. I'll pass that order. You are on behalf of?
Satyajit Mahapatra.
Satyajit is there, yes. Date करो तो 28 है?
27 my lord. 27 became infructuous because I challenged the rejection of my entry maintenance petition. But in the meantime, the original case has been dismissed, my lord.
So kindly give the details. Don't make your memo sketchy.
Like,
Actually, you are including that.
copy of the order.
Okay. This has been dismissed, you are saying. CP has been dismissed.
CP has been dismissed, yes.
CP filed by you.
No.
By the husband.
Husband.
So 25, CP then 25, no scope of 25. Either 144 or other DB.
Section 9 case.
Section 9 upon file करते
No. Section 9 filed by husband.
The section 9 has been dismissed. Okay.
Certified copy.
So certified copy upon account. Attested copy दियो. ଦେଇପାରିବେ ନା ସେ କରିବେ ଅଛି ଗୋଟେ certified attested copy ଦେଇ
From 29 lords.
the order will be passed.
Atom 29 lords.
Yes.
Praying for a short adjournment to file the written note of submission.
Written note submission I don't require, sir. You structure your arguments on the written note of submission. I'll go by the pleadings.
Absolutely.
Because once I start looking into written note of submission, there is every possibility that I will not miss something. First you place your pleadings, then may be required. So to start with, please go through the upon date कर दियो 20 आप कहाँ पे करचों?
For the petitioner lords.
On behalf of the senior
Lords.
अपन का नाम है?
Ghanoshyam Banji.
Sorry sir.
Ghanoshyam Banji.
Ghanoshyam Banji.
Banji. BANJI.
BNJ. Yes, you have power here. Yes. Have you informed Mr. Panda? Yarananda Panda? He'll be waiting for you. Always, after notice matters, inform the other side. They are waiting and they are mentioning at 4 or 3 that we are not informed. They will attend other cases or they may go home, whatever. But they shouldn't be kept waiting by you.
Lords.
कौन कहले? नहीं आपण से जो 28 टा कौन कले जो सॉरी 27 टा बुझले लिखी रखछंती तो गोटे कॉपी रहबा ता अटेस्टेड कॉपी यस 30 31 आपण को 13 4 कहले 30 31 32 to 37
Item number 32.
yes
I'm praying for a short adjournment.
stay
Stage.
what is that about stay hi अछि
Stay अच्छी है.
कौन what is the matter
इधर transfer between criminal
म्हणजे
case.
कोणता ट्रान्सफर चाहुଛନ୍ତି सर what you are seeking transfer from
Trial
what is the offenses sir what is the matter means what are the offenses Correct. 32 date कर दियो. But one thing, I am not passing interim orders. You must understand. Suppose it is not reached, it is simply adjourned.
Interim order.
Interim order I cannot. Out of turn, I am not taking up matters. I will go serially. You must understand that. That is why I have been told that I will pass orders when the matter reaches.
In this matter, seeking
आपको 32 যদি reach হবো তাহলে নলে ଗୋଟେ simple date ନେଇଯିବି. କେବେ date ଚାହୁଁଛନ୍ତି?
My lord, any order.
Any date କିଛି ନାହିଁ କ୍ୟାଲେଣ୍ଡର ରେ. ଆପଣଙ୍କର 1 ରୁ ଆରମ୍ଭ 30 ରେ ସରୁଛି. Any date my lord PJ ସେଟା କଣ ଅଛି କ୍ୟାଲେଣ୍ଡର ରେ? I am not displeased to list any matter actually.
First week of April. First week of April.
Inform Mr. Lenka.
My lord, item
ठीक है ଗୋଟେ କାମ ସରୁ.
Interim order.
Interim orders extend କରିବାକୁ ହେଲେ you have to wait. I am not taking up matters and pass extend interim orders. ଆପଣଙ୍କର କରିବେନି date ନିଅନ୍ତୁ, it will be posted. Correct? Yes.
item 34.
34.
I am for the opposite party. My senior Vijay Corridor is hospitalized due to cardiac blockages.
You have to inform
Yes,
the
yes.
other side.
Yes.
34 date कर दियंतु.
24. I want to make a mention, my lord. Item 28. Pray for an adjournment also.
ଆପଣ କାହା ପାଇଁ?
PK Malik lordship.
ଆପଣ କାହା ପାଇଁ appear କରୁଛନ୍ତି? Other side ପାଇଁ?
Petitioner.
ନାଇଁ petition ପାଇଁ
My lord.
କେକେ ସେଠି appear କରିସାରିଲେଣି?
Petitioner.
କେକେ ସେଠି appear କରିସାରିଲେଣି? ଆପଣ ଯଦି BK ମଲ୍ଲିକ on behalf of କେକେ ସେଠି on behalf of S ମହାପାତ୍ର ନା କଣ?
Yes, ma'am. Yes,
ଗୋଟେ ଦିଥର କାଇଁ ମେନସନ କରୁଛନ୍ତି? କେକେ ସେଠି ଆସିକି
ma'am.
କମଳାକାନ୍ତ ଆସିଲେ
Yes, yes,
କହିକି
yes.
ଗଲେଣି ସତ୍ୟଜିତଙ୍କ ପାଇଁ। ଆପଣ ବି ଫେର କହୁଛନ୍ତି, ଆପଣ କାହା ପାଇଁ କହୁଛନ୍ତି?
Also, I have the petitioner sent also. I don't know.
ସେ interim order extend ହବନି। interim order ସେଥିରେ ଲେଖା ଯେ ଆପଣ you have to satisfy the decree, secure the decree. 34, 37 ଆଉ କେନା ଆପଣଙ୍କର? 51. Other side ନାହାନ୍ତି? Mr. Ray, standing counsel
Mr. Rai.
41 କରିଦିଅ।
Yes, sir.
We commencing 24। ଆପଣ ଯୋଉ କହୁନାହାନ୍ତି we commencing କୁହନ୍ତୁ, କାହିଁକିନା ସେ ଡେଟ୍ ଟା କନଫ୍ୟୁଜନ ହଉଛି ସେଠି। interim order I am not extending. ଯଦି matter reach କଲାନି, I am not touching interim order. Please appreciate that. Because for adjournment, unless only taking up the matter, passing order, then signed, then sent to section, then to see listing, all these things by computer it is been posted. Interim order remains unchanged.
It melody listed melody earlier.
Yes, if it reaches, definitely. Of course.
I've already given the message to him.
Yes. Mr. A.K. Naik. Yes.
Item 1. On behalf of Mr. Sohimel. Is this matter coming to my referral?
My lordship, this matter may be come in the roster bench because this corporation doesn't want to mediate this matter. My lordship. Because if your lordship will see the prayer of the petitioner, it is regarding the quashing of the impugned order.
Yes.
I mean rejection order passed by the corporation. My lordship.
But a merit adjudication has to be there.
So it cannot be regarding the mediation.
Mr. I'm sorry, I forgot your short name. J.R. Kuntia. Jyoti Ranjan Kuntia for Mr. K.K. Swain for the petitioner. Mrs. आपको पावर तो नहीं?
Sarita Maharana.
पावर तो नहीं?
No, my lordship, 2011.
ये Sarita Maharana for the opposite party.
Opposite part number 2, 3 and 4.
So P.K. Prem Kumar Mohanty.
State, not a party.
Yes, state is a
State is
party.
Then Kumar Manki for the OP number
One.
1 and 2.
2 is for my lordship OHPC. It's a hydropower. It is the project of the upper Kolkata project. Belongs to OHPC.
Can you look at the case brief?
Yes.
First title. OP number 1 and 2. Ms. Sarita Marana, MS Sarita Marana on behalf of 3 and 4. Chief Engineer Upper Kolkata.
That belongs to OHPC. But they have not written in the address.
So,
It is a project.
so that you are adding those words.
My lord, it's a project.
So unless it is written,
Yes.
that's the difficulty.
Yes.
So, ଆପଣ appear କରୁଛନ୍ତି Mr. Mahanti 2 ପାଇଁ 2 ପାଇଁ କରୁଛନ୍ତି ଯଦିଓ ଏଠି chief engineer
2 man.
1 and 2.
1 and 2.
so see what I hope what she is saying that chief engineer Upper Kolab is also under the corporation. I have doubts, of course I have doubts, definite doubts, because I think I have appeared for them without appearing for the corporation. But chief engineer Upper Kolab I have appeared in several cases during maybe arbitration. So 1 and 2 था confusion करो. You open instruction if they are not
3 and
1 and 2, 3 and 4 लिख ले. It is submitted. The matter is listed under the heading quote करते हुए for referral to special regime for a nation. Caption टा लिखो ऊपर जोड़ा है. It is submitted by the learned counsel for Ms. Marana for the 3 and 4 that the petitioner challenges the order dated 11/11/2011 passed by the OP number 3 and passed by the authorities under the OP number 3 and 4 rejecting the representation dated 22/10/2010. So it started this representation disposal is since when it is continuing? For 16 years. 1996, 30 years.
And the matter was also not listed, my lordship. Only 2 times the matter was.
No, cause of action is 36. I disposed of it for consideration of representation as High Court.
Yes.
In 2026, it comes back to me. So that I was trying to understand that what I have achieved. Like I was discussing regarding maintenance applications everywhere where I have involved. I mean, I'm the court, not I. When I say I, not exactly as a person, of course. If it would have been adjudicated, say 96, maybe 10 years, 2006, the person would have at least satisfied that he could not get anything. Let us assume the worst case scenario, writ is dismissed.
In the meantime, it is written. Till today,
30 years, sir, how many, sir, maximum period is 33 years. Now it is reduced of course. Rejecting his representation dated 22/10/2010 pursuant to the order passed by this court dated 8/7/2011 in WPC number देखिए लिखिए भूलभाल है जो पेज 19 रे अछि 16564 of 2011 for regularization of services
scale the matrix
for grant of trained matrix
scale
of pay as the petitioner was working as a teacher in
Kabishiri ME school under Orissa Hydro Power Corporation Limited.
In so and so school under the Odisha Hydropower Corporation Limited. The learned counsel for the petitioner also submits that the matter requires adjudication on merits and may be listed before the assigned bench. Accordingly, the writ applications and the learned additional standing counsel also makes a similar submission. Accordingly, the matter shall be listed before the assigned bench registry to do the needful. तापरटा
Sub-item Manaship, we are appearing for opposite part number 2 and 3.
Mr. Mahapatra,
Same sir.
say scale.
Mile.
Upon the representation.
Mile.
केबे अपन रिप्रेजेंटेशन हैला इम्प्यून ऑर्डर टा मिस्टर प्रफुल्ल कुमार सब आइटम लिखिबे WPC 29831 of 2011 एम्प्लॉयर का पावर कॉर्पोरेशन हाइड्रोलिक पावर कॉर्पोरेशन the matter is listed under the heading एते पूराटा लिखिबे so and so tag to the WPC number 31572 of 2011. So there be 22/10
That was 11/5. The representation was 11/5, 2011.
order date
Order.
ताले same order टा reproduce करिवे ले appearance से लिखिबे Mr. PK प्रेम कुमार महांती for OP number 1 2 and 3 होचंती सरिता महाराणा DP नंदा
Yes, yes.
लिखिए मिस्टर DP नंदा सीनियर काउंसिल along with मिस सरिता महाराणा MS सरिता महाराणा ऊपर भी से लिख दे अरोट डेटा जान परिवे इम्प्यून ऑर्डर एथरे होची पास ऑर्डर पढु ना कहि देम आगे ना तो तळे लेखंतु 22/10/2011 रिप्रेजेंटेशन डेटेड लेखंतु 11/5/2011 तो लिखिबेनी अनेक रहिबे कलम चलीबेनी आपनकर पिटिशनर चैलेंजेस ऑर्डर डेटेड 22/10/2011 देखिले रिप्रेजेंटेशन डेटेड 11/5/2011 ऑर्डर डेटेड 3/5/2011 03.05.2011 passed by this court in WPC number 22281/2010. These are the dates that change huge. Assigned bench quota. This is the bench.
This is the bench.
केबे आसीबो ताले कोंतु 11/2011 मैटर नेक्स्ट वीक तो करी हबनी आफ्टर नोटिस but the matter shall be listed for admission in the week commencing 13/4/2026.
Item 2.
Yes, madam.
May I please announce?
Yes, please.
Kindly this matter urgently.
ओनो एमती कले केमती 18 मसे मैटर 8 वर्ष परे आपन नाटा आपन कहा पे अफेयर करचोंदी
एसआर साहब सुषमा रानी साहब
एनी पिटिशनर कांती टू तुम तो लिखो दौड़ा
only 2 week letters.
just 1 second. You take your seat. आपन को नाटा सॉरी I forgot your name. और नाटा कहले
दीपाली महारण्या.
दीपाली महाराणा
महारण्या.
महारण्या महारण्या
RANY.
ओहो NYA. This means Maharanya. The matter is listed under the heading so and so likhiwe. None appears for the petitioner when the matter is called. Opposite party MS Dipali Maharanya on behalf of Susoma Rani Sahoo. MS Susamanani Sahoo, opposite party. Take your seat. I'll take some time in dictating the order. The matter was presented before this court. Yes, always sit in the front row because you are the arguing counsel. So those 4 seats, 5 seats are 6 seats are for arguing counsel. Please take your seat. You conserve your energy for arguing. The matter was presented before this court on 09.11.2011. Notices were issued by a division bench on 16.11.2011. Thereafter, counter affidavit has been filed. Stop. Upon change of determination of benches of this court, the matter was listed before the coordinate bench on 21/9/2015. Thereafter, the matter has not been listed for the last 11 years. The matter shall be listed for orders. ଆଜି କେତେ ଅଛି ତାରିଖ? 18 ଆଣିବେ ସୁବିଧା ଯେବେ ସୁବିଧା କୁହନ୍ତୁ। I am not burdening you. ତ କିଏ ଆସୁନାହାନ୍ତି କଣ କରିବା? listed on 19 ଆଜ୍ଞା 19/3/2024 indicating that the matter shall be disposed of. ତାପରେ ଲିଖିବେ the copy the next date of listing as well as the order shall be communicated to the learned counsel for the petitioner. I hope you understood the order. Pending since 2011, after 15 for the last 11 years, not listed. Yes. You inform your senior accordingly. Yes. And always read the brief. What is the matter about? Don't spend time in the chamber by just gossiping or now the mobile phone is a greatest distraction. Mobile phone, read the case law. Correct. Mr. Panda, MK Panda.
Pleasant.
Yes.
When a state is agree, if state is agree, then it can be sent to mediation.
So problem, Mr. Panda, is that if the requisitioning authority is not there.
I am filing memo. Initially the order is not a challenge. I am adding state of Odisha. Different to secretary.
Then it has to be allowed. Mr. Mahanti.
Take instruction.
No, please. No, I am not asking that, sir. Now there is only the LA's party. The requisitioning department for whom the land is acquired and who is to pay the money is not a party. Mr. Panda is saying that he is filing memo to implead. That I am asking you.
Memo.
ଆପଣ କହିବେ ଆଇଏ ଫାଇଲ କରିବା ପାଇଁ ବଟ୍ ଆପଣ ଏଇ ପ୍ରୋସିଜରାଲ ଫର୍ମାଲିଟିଜ ରେ ଯଦି କରିବେ the matter gets delayed. I understand what you are saying. You are right. And already the matter is kept pending since 2022. Now I cannot suppose sending mediation. You are the land acquisition officer. You do not have anything to say. Whatever money will be given, you will disperse to the land user.
Let me take instruction.
So you accept notice. I am impleading. You accept notice. Take instruction.
Yes.
No, please feel free to say because don't never have a impression that I am obstructing you.
No.
Not allowing you to submit.
No.
Because my job is not that also.
No.
If so that is how I am interacting with you to explain that what is being done. Mr. MK Panda for the petition appellant. Mr. Prem Kumar Mahanti, additional standing counsel for the respondent. Along with on behalf of the learned advocate general. The matter is listed for listed under the heading for referral to the special mediation drive 2.0 mediation for the nation. It is submitted by the learned counsel, Mr. For the appellant, land loser, that if the opposite party state will agree, the matter can be sent for mediation. In the writ application, in the appeal, the requisitioning authority for the project, co-project
Rengali irrigation.
for the Rengali irrigation project, that is Department of Water Resources. That is the present. That is at present. It is at present the Department of Water Resources is not the party. The land acquisition officer, being the who is the statutory authority, is the party. It is submitted by the learned counsel for the appellant that he shall implead the party, implead the department, implead the government department as a party, for which he files memo. The memo is taken on record, scanned copy be updated. Prayer for impleading the department on whose behalf the land has been acquired is allowed. The learned counsel shall have the liberty to add party. File add State of Orissa, Department of Water Resources, represented through Chief Secretary, Department of Irrigation, Department of Water Resources as R2. The addition to be reflected in the cause title of the appeal shall be endorsed by the learned counsel for the appellant and shall also be countersigned by the court master. Issue notice to the newly added R2. Learned additional standing counsel appears and waives notice. Issue notice is a line. Learned additional standing counsel appears and waives notice. Later on, extra copy be served on the learned additional standing counsel to obtain instruction. Stop. The learned additional standing counsel shall obtain a specific instruction regarding referral of the matter for mediation to mediation. The matter shall be listed under the same heading in the in the week commencing 13/4/2026. So, Bhanti, one more suggestion. Whenever you are writing to government, you write this thing for referral to special mediation drive 2.0 mediation for nation is initiated by the Honorable Apex Court. The matters are being listed because they don't understand these things. They might not. So you have to explain them that what is the purpose of mediation and all these things. That will help. That will help all of us. You, Mr. Panda, and me. Yes. Vikress. Second, go to extra copy, Mr. Panda. Extra copy be served within 2-3 days.
Today.
Extra copy of the appeal memo along with other papers.
In course of the day.
Shall be served on the learned AC within 2 or 3 days.
Fine.
Mr. Vishwa Prakash Dhala for the appellant. Yes, Mr. Dhala.
The state will be agreed. The same thing.
Have you made the person who will pay the money the party? Because if land acquisition officer cannot say that how much he will pay or not, because he receives the money and pays you. LAO. He's a statutory authority.
The engineer in chief was also.
Acha, party got you. Yes,
Right.
you have met party. Say 13 instruction. Okay. The matter is listed for under the heading for referral to the special mediation director Puran. The learned counsel for the appellate submits that respondent Hochanti, Mr. Prem Kumar Mahanti for 1 and 2. R1 na? Yes. It is submitted by the learned counsel for the appellant that if the opposite party state will agree, the matter should be referred to mediation so that an amicable settlement can be arrived acceptable to both the parties. The learned additional standing counsel seeks adjournment to obtain instruction in response to the said submission. Stop. Accordingly, the matter shall be listed in the week commencing 13/4/2026. The learned AEC obtain instruction as indicated above. Yes. Next.
Item 5.
The Bera, Shaky Bera for the petitioner.
The fresh matter, man.
Sir, 22 in 26 cannot be fresh. It has to be stale after 4 years.
No, my lord. There is last.
What is the
last
instruction?
option I remove all the defects, my lord.
Okay.
Now it the fresh comes to fresh addition.
So, what is the amount due till now and how much you have paid? It is as simple as that.
Present petition is the father-in-law of opposite party 1, my lord.
Correct.
Yes, ma'am.
Father-in-law is not entitled to maintain. Have you taken that plea before the show the written statement?
See,
Keep it very simple. You are not sufficient experience.
experience is not entitled to.
So what is your stand before the trial court? Because you are not arguing before me. This is a revision application.
Yes, ma'am.
And you might have heard I said this in open court that Supreme Court in one matter has said that lack of application of mind on part of the High Court by Justice Deepak Mishra. When High Court interfered, because scope of revision is very less. Scope of revision, it can't be reappraisal of evidence. It cannot be, if I feel something different, conclusion can be concluded. That cannot be the, judgment of this court. If substantial justice has been done, the learned trial court has appraised the evidence correctly, that is enough. So you have to show now that you have filed WS, adduced evidence that denying your liability.
Yes. May I prefer is the notice is most required.
Notice, mechanical issuance of notice becomes illegal. Issuance of notice has to have legal sanction. Interfering in a judicial order by a high court has to have, it has to be within the legal norms. I don't know how this impression has been created. I never had this impression that High Court is sitting here to issue notice. Exercising 227 or 226.
Yes.
Or regional jurisdiction. And this has been now settled by Supreme Court. The nature of 125 award. What is the concept? Way back, Justice Krishna has judgment under Article 15(3) ameliorative provision. So High Court's job is not to whoever comes issue notice and then wait and watch. Now suppose now you are serious in challenging, at least secure the money decree. After 2021, 125 is earlier also it was, but now a very definite judicial pronouncement in Rajneesh versus Neha.
So I will take institution while.
So A.K. Behra for the petitioner, Pujit Party plan. The matter is listed for fresh admission, though it is pending since 2022. Stuff. Defects were removed as directed by order dated 15/1/2026. Thereafter, the matter has been listed. You take your seat. I'll dictate order.
Yes, sir.
I'll take some 2-3 minutes at least. The petitioner husband is before this court, challenging the judgment dated 29/1/2020. এটা କଣ ଆପଣଙ୍କର କେମିତି ଭୁଲ ହେଲା ଦେଖିଲେ ବୁକ୍ ମାର୍କରେ କଣ ଲେଖିଛନ୍ତି ପ୍ରେୟାର ପରେ ଆନେକ୍ସର 1 ଡେଟ୍ କେତେ ଲେଖିଛନ୍ତି ଆପଣ ମାନେ ମୁଁ ଆପଣ ଇନ୍ ପର୍ସନ କହୁନି କଣ ଲେଖା ହେଇଛି ଏଠି 9/12/2021 କଣ ଜଜମେଣ୍ଟ ଡେଟ୍ ଦେଖିଲେ ବର୍ତ୍ତମାନ ପେଜ 8 ମୁଁ ଖୋଲିଛି 29/20/20 ଆପଣ ଏଗୁଡା ଟିକେ ଲେଖିକି ରଖନ୍ତୁ ତାଙ୍କୁ ଜଣାନ୍ତୁ ଯେ ଦିସ୍ ଥିଙ୍ଗ ସୁଡ୍ ନଟ୍ ହ୍ୟାପନ୍ ଇଟ୍ସ ଏ କୋର୍ଟ ଅଫ ରେକର୍ଡ ଆପଣ କହିବେ ଯେ ଆପଣ ଲେଖିବେ ଯେ ଆଇଟମ 5 ରେ ପ୍ରିପେୟାରିଂ ଦ ବୁକ୍ ମାର୍କ ଜଜମେଣ୍ଟ ଡେଟ୍ ଭୁଲ ଲେଖିଛନ୍ତି ଜଜମେଣ୍ଟ କୁ ଅର୍ଡର ଲେଖୁଛନ୍ତି କଣ ଲେଖିବେ हाँ 29/20/20 passed by the Lord Judge Family Court Noyagarh CP number 116/2018 the said CP was filed under section 19 of the Hindu Adoption and Maintenance Act, 1956 by the petitioner by the opposite party wife in the marriage being the petitioner. Again?
She is the daughter-in-law.
Sorry, I'm so sorry. You said that. Being the daughter-in-law of the marriage. Sorry, no, daughter-in-law of the
Petition.
of the sentence I can't have to What is that? Huh. By the husband, by the opposite party daughter-in-law. Marriage ta katti. So, the opposite party being the father-in-law.
No, while. Opposite party is the daughter-in-law of present petitioner.
CP.
Yes, sir.
The said CP was filed.
Yes, sir.
CP file kale buhu au natuli against the father-in-law. That is your case. Duryodhana kiye? Duryodhana alias Batua.
Father-in-law.
ଆପଣ ରେଫର କରୁଛନ୍ତି RPFM କୁ କରୁଛି CP କୁ.
Yes, yes.
CP ର ଅପୋଜିଟ ପାର୍ଟି କିଏ ଥିଲେ? ରେସ୍ପଣ୍ଡେଣ୍ଟ କିଏ ଥିଲେ? ଏନିୱେ ରେସ୍ପଣ୍ଡେଣ୍ଟ.
Duryodhana.
ଅର୍ଡର ଠିକ
Present person.
କଣ Also on behalf of the minor baby girl, the present petitioner being the respondent before the learned no, not before in the said CP. The application was filed after the husband of the lady passed away. Husband of the lady, son of the respondent, passed away. the CP was favored. However, directing payment of maintenance of rupees 3,000 for the opposite party daughter-in-law and 1,500 for the minor child. In view of the judgment passed by the Honorable Apex Court in Rajneesh versus Neha, the amount directed to be paid in an application under Section 19 of the Hindu Adoption and Maintenance Act is in the nature of a money decree. The learned counsel for the appellant, the learned counsel for the petitioner has adjournment to obtain instruction. What is the amount due till date? How much amount has been paid, if any, if any? And whether the petitioner will secure the amount before this court for challenging the same. Stop. List in the week comment. जो मेरा के बेस ले हम तेरो चारी yes please
না না
আরে পিটিশনটা মিশান তো
পিটিশনটা ঠিক না না আমার ভুল এটা আমার ঠিক আছে না
ଆପଣ ବି ଭୁଲ ଅଛି
ନା ନା ଆମର ଠିକ ଅଛି
ତାକୁ ଦେଖାନ୍ତୁ ଆରେ ମତେ ବଢିଆ ଆପଣଙ୍କର ଆପଣ ଇଣ୍ଡେକ୍ସ ଟା କାଢି ମିଳାନ୍ତୁ ସେ ଗୋଟେ ଦେଖୁଛନ୍ତି ହି ହାଜ ସିନ୍ ଇଟ୍ ଆପଣ ଇଣ୍ଡେକ୍ସ ତାକୁ ଦେଖନ୍ତୁ
ଆପଣ ପୁରା 9/12 ନୁହେଁ 9/21
ଇଣ୍ଡେକ୍ସ ଆପଣ ତିଆରି କରିଛନ୍ତି ନା
କରେକ୍ଟ
ଆପଣ ଇଣ୍ଡେକ୍ସ ଟାରେ ସେ କହୁଛନ୍ତି ଇଣ୍ଡେକ୍ସ ଟା ଦେଖନ୍ତୁ
just correct me.
ଆରେ ରୁହନ୍ତୁ ସେଟା ସେମିତି କରାଯାଏ ଫାଇଲିଂ ପରେ କଣ କରେକ୍ସନ ଆଲାଉଡ ଅର୍ଡର କରିବାକୁ ପଡିବ ଟିକେ the bookmarks prepared by the computer section handling the briefs indicates that Annexure 1 to be the order dated 9/12/2021 stuff. The index of the writ application also shows that Annexure 1 to be the order dated 9/12/2021. Perusal of the Annexure 1 at page 8 of the brief indicates that it is about it is copy of the certified copy of the judgment dated 29/2020 passed in CP number 116/2018. The learned counsel for the petitioner submit that he shall carry out necessary correction in the index. Correct?
Yes, no.
In the court itself, the prayer is allowed. Prayer is allowed. The petitioner, learned counsel, is permitted to correct the index for the typographical error, which shall bear his signature and shall be countersigned by the court master. Court brief रे आपण brief रे correct कर दियो. Judgment dated 29/2020. Of the order लिखचंदी. Copy of the judgment. पेज टा ठीक होला पेज अपन काउंट ठीक कर लिखथिबे पेज मार्क ठीक अछि ने चेक कर दियंतु हम सेटा फेर आउथरे प्रॉब्लम हे जिवो अपन एसआर बेले केंति पॉइंट आउट करना अरे अपन तो अपन लिखिबे ना द इंडेक्स डज नॉट मैच विथ द annexure 1 सेटा की पॉइंट आउट करियो सी लिखचंदी को नेक्स्ट
Hon'Ble.
Yes, please. Item 6 रे item 6 टा कौन अछि fresh matter. Mr. BC Parija, item 6 लिखो तो Mr. BC Parija for the adjournment is sought for on behalf of the petitioner again, though it was granted earlier on 2/2/2026 to enable the learned counsel to obtain instruction. To grant further opportunity, list in the week commencing 30/3/2026.
Item 7.
Mr. S.K. Mahanti, na? Mr. S. Mahanti for the petitioner, opposite party blank. It is submitted by the learned counsel for the petitioner that his leader, Mr. P.C. Jena, is busy in court work at Puri, and the matter may be adjourned. Stop. To grant further opportunity, the matter shall be listed in the week commencing 30/3/2026. Mr. S.K. Mahanti for the petitioner.
It is there.
Mr. Prem Kumar Mahanti, additional standing counsel for the opposite party. The matter is again sought to be adjourned on behalf of the petitioner. Though it was adjourned earlier on 27/2026, heard extensively on 30/1/2026, and again adjourned on 26/2/2026. It is submitted by the learned counsel for the petitioner that in absence of his leader, submitted that his leader, Mr. P.C. Jena, is busy in court work at Puri. The matter may be adjourned. To grant opportunity once again to the petitioner, list in the week commencing 30/3. Yes, next.
Item 9.
It may please your lordship and bring for an adjournment.
Your name, madam?
It is Mr.
I. Misra. Miss Itisri Misra on behalf of A. Misra for the petitioner. Adjournment is sought for on behalf of the petitioner in absence of the learned arguing counsel. The matter shall be listed for fresh admission in the week commencing 30/3/2026. सब गुड़ाक लिखिदेवे shall be listed for fresh admission. गुड़ाक जहाँ अच्छी से लिखिदेवे.
Item 10.
Passover କରିଥାନ୍ତୁ. Passover କରିଥାନ୍ତୁ.
Item 11.
Passover କରିଥାନ୍ତୁ.
Item 12.
Mr. Amir Misra, senior counsel, instructed by Mr. P.S. Mahanti.
Chandrasekhar Padhi.
Mr. Chandrasekhar Padhi for the petitioner. Mr. Prem Kumar Mahanti for the opposite party, AC. Item 12.
May I please, Your Lordship?
Yes, please.
I may begin with that I am here for Your Lordship, maybe that if there will be a possibility of some kind of settlement, here I have challenged the certificate proceeding itself. The background little I will place you for Your Lordship to impress upon Your Lordship why I have come with that purpose. But I was given a stone quarry. Now what has happened, there were forest growth on the stone quarry. Villagers did not allow me to remove those forest growth, nor the authorities, namely Tahsildar and other authorities, mining authorities, or had any intervention with regard to that. I have not operated the quarry at all. And subject to if Your Lordship entertains my case, if my friends taken instruction also, I have not operated even not one stone I have removed from the quarry. However, in terms of the
this quarry is a quarry permit or auction?
It was given normal quarry, not auction. So in terms of the agreement, now they have raised a public demand.
But it is in that register of queries maintained by the Tahsil. They maintain a register. They have a record of, and it is identified as a query. This question is in the context because you are saying that it has forest growth. Usually forest area, they are not marked as queries.
Forest means there were plants. I cannot say exactly total forest, but those are not allowed to be removed.
Whoever has seen Bhubaneswar remembers it to be a dense forest.
And
beyond station in 50s.
And some areas are still recorded in Bhubaneswar.
Correct. Record is actually correct. Whoever has seen in 50s Bhubaneswar, beyond station was forest.
But they have raised a demand. Now, as for the agreement,
usually in man and mineral, the writs are filed challenging the demands or challenging the. So there is no other adjudication challenging the demand because non-operation of the query usually invites a lot of adjudication or say good briefs for the lawyers.
Here, I would be.
Maybe you will be in hundreds.
Here,
man and mineral writ applications file in hundreds.
Here, the purpose of filing is if there can be some kind of media where.
But the problem is in certificate case, I cannot venture into that.
No,
I don't have jurisdiction. If I have jurisdiction for man and mineral, no.
It will be only a case of possibly, if at all, it's a case of Your Lordship is having so many local adalats in that spirit. If at all.
That they have a difficulty. They are saying in revenue demands. Yesterday only one matter, I think it was referred for mediation by the coordinate bench, land acquisition, which can be settled. But they say that for us, it is very difficult to agree for reduction of even 1 rupee. I mean, in common parlance.
Interest charge करछंती जोटा तांकर अछि
Tahsildar or that unless there is a policy by the state, they don't obviously they will protect themselves.
True it is, my lord. I am at the initial stage. Whether you are
but what you are saying, you are very clear in saying that this is a certificate case.
Absolutely, my
lord. If it is a minor mineral that matter, then obviously it has to be challenged before the appropriate.
I am not in a position now to go back to that situation. I should have done it at that stage. ଯେତେବେଳେ operate ହେଇପାରୁନଥିଲା, ସେତେବେଳେ I should have gone that stage. So it has travelled beyond that. So I am only praying if Your Lordship entertains.
This is 2015.
25 Your Lordship. 2025 pro certificate initiation.
Then the operation period.
Operation period. ତେଣୁ ଯେଟା ଏତେ ଦିନ
25 operation period.
ନା
easily challenge.
Certificate case ଟା.
15 I think is the period of operation from
9th 2015.
15/16 ରୁ 19/20.
5 years ଥିଲା.
Still I think you can challenge it to take that instruction.
Present.
Today I started with 2011 service matter. I have this court has disposed of for representation disposal, and after 26 years he has lost a age of superannuation. I am asked to again consider on merits.
Now that this certificate case has come, which will have ramifications, I am before Your Lordship, and I am a bona fide petitioner for Your Lordship because I am not here just to escape.
No, once you enter into an agreement, it's a revenue matter. So
True it is.
they have to. Right?
Well, if at all initially your
So
lordship,
are you agreeing for depositing any amount? Is that
no,
the
if your
instruction?
lordship directs, I will only humbly pray a very
No,
token
honestly,
amount.
because my problem is now, as a judge, as a court rather, that I am not adjudicating the criminal matter.
Absolutely no.
I am only considering the
On the certificate.
certificate.
I have not challenged the other.
It is apparently valid. If you look at page 13, 12 and 13, they have given the details.
I am not here also questioning on merit.
Because royalty and all these things are bound to be paid.
Your lordship will peruse my writ petition also. I am not, unlike in the other case where I was opposing, my learned senior Sri S.P. Mishra was appearing here. I am not here just to show anything to escape. I am here possibly, if at all I can manage to convince your
I think
lordship.
you have to challenge the demand.
That matter I will have to find out. And now, my lord,
So I'm simply adjourning.
I am praying, my lord, here, your lordship may kindly.
So what you can do, I direct that you take an adjournment before the certificate.
May I pray one thing?
That much I can, that some cases I passed that out.
May I pray one thing? Subject to your lordship's kind consideration, I'll deposit some amount. Your lordship may direct to show my bona fide. And your lordship may
even to that extent, I will show you indulgence. Till you obtain instruction in challenging the demand, the matter will be adjourned before the authority. But I will not record that. Then when you come back, then if I am interfering with this proceeding, then I will ask you to deposit. Both ways. By the next date of adjournment, you obtain instruction. You are challenging and interference in this matter. If I require you, then I'll ask you for deposit. The amount. Today, what is the next date in certificate case?
In fact, it was 6 to January 2026.
Can you get that date? Because I will have a timeline. I will pass it over. If it is, suppose now, let us, what I am telling, this example, suppose it is posted to 30th of March. You obtain instruction by 20th of March or 16th of March. Today is 12th. It can be listed in the, if 30th, it can be listed in the 23rd.
In fact, there was a desperate communication by my associate since morning. Possibly the lawyer is not keeping well. That's what his associate was saying. He has not responded to. I am praying your lordship may give me a small protection breather. I'll come back. I have understood your lordship.
What is the date? How I'll record that? On the next date, this is the date, the authority in season of the matter shall adjourn the matter.
Your lordship
that much I have to reflect.
Your lordship may kindly take up tomorrow because I don't know whether he will respond till launch because he has not responded. And tomorrow, if your lordship please.
Yes, Mr. Mahanti, for adjournment. Correct. He will file a difficulty, but today it is to be adjourned. तो कल ही आसु ना से डेट आपण कहि परिबे कि नेक्स्ट डेट अछि
आज्ञा
ठीक अछि एटा केते नंबर आइटम 12 एटा सिंपली adjourn कर दे हला ताकू फेरांतु नि फाइल सो दैट अगेन कैन नॉट बी लिस्टेड अगेन
obliged
आपण को ड्यूरिंग पेंडेंसी अपील मेंटेनेबल during OPDR proceeding, suppose OPDR proceeding is initiated, Mr. Mishra, you just examine that aspect also.
And during pendency or what?
Anyway, but if there is a proposition is advanced, please take note of that. Because you are challenging the initiation.
Yes.
He said that appeal. So that is the discussion now.
Yes. Not a case of challenging any order.
Mr. Ajit Kumar Tripathi for the petitioner.
Yes.
Yes, please.
In this case, I want to withdraw the case. The husband filed this case challenging the enhancement of maintenance.
So please file memo.
Yes, I am just filing now.
So Ajit Kumar Tripathi for the petitioner, opposite party blank. You take your seat, I'll dictate the order. It'll take some time. Upon reproduce कर दियो तो para 1, para 2 रू 2 to 8. 1, 2, 3, 4 করে reproduce হয়ে গেল। The matter was earlier heard at length and detailed order was passed on 4/2/2026. Today, when the matter is taken up, learned counsel for the petitioner files memo of date which states thus quote करते ले तापर लिखिए the memo shall be taken on record, scanned copy be updated. In view of the memo filed, the matter is disposed of. Copy of this order shall be forwarded to the learned judge, Family Court, Cuttack, to be put in the records of CRP criminal proceeding number 470/2014. Yes. Yes, please. Next. ब्रैकेट रे नाटा लिखि देते कहले हां ठीक है। The matter was presented before this court on 8/4/2022. The matter was presented before this court on 8/4/2022. Defects are directed to be removed by the Deputy Judicial Law Command Logipas by order dated office the Spochisi. So far, the matter was listed before this bench on 19/26 and adjourned for removal of defects, granting time of 10 days. Stop. Today the matter is the matter is listed. The defects have not been removed. The learned counsel for the petitioner files memo of date which states thus. The memos can be taken on record, scan copy be updated. The petition stands in view of the above, the petition stands disposed of. Ajay Kumar Marana for the petitioner. Item 11. ଆପଣ ସିରିୟଲି ଡାକିବେ ନା ଏମିତି କଣ କରିବା କଥା ଆରମ୍ଭ କୋଉଠୁ କଲେ
item 10
ତାପରେ
item 11
May I please, Your Lordship?
please
Here is
Mr. Ajay Kumar ଯୋଉଟାକ ରିକଲ୍ କରୁଛନ୍ତି ତାକୁ ମେନସନ କରୁଥିଲେ
Seeking for a direction for early disposal of the divorce petition filed by the wife petitioner before the Learned Judge Family Court, Cuttack, my lord. Though the petition has been filed in the year...
Sir, the problem is Supreme Court has injuncted. Please examine Asian resurfacing and the next judgment by Justice Oak.
Willows.
Supreme Court has observed that the High Court should not target matters and despite direction by the Supreme Court,
Yes.
what the High Court should not do, it is doing every day. After that kind of comments from the
Yes, sir.
apex court, and of course your concern is right. I mean the court is also conscious of that.
Since
But
I'm
if,
a- since I'm a
but
lady,
if
I'm
other
thinking-
cases and earlier cases are pending,
I concede with Your Lordship.
then the problem is, then the solution is perhaps.
Yes.
You may take a direction that I will make an observation that they both will cooperate.
Since the husband is not cooperating, my lord, if Your Lordship will tell
So
us-
then
And as per
you
section
must
36 of
you
the-
must file an application as provided in the CPC. if you are the defendant or the petitioner there?
I'm the petitioner.
You are the
I'm the
petitioner.
wife. The
You are
wife
the
has
petitioner.
forward with-
So there is specific provision in the statute which says that when the defendant doesn't appear, what order can be passed by the court?
Yes. Here-
That
in-
application is to be filed.
In my case, defendant has appeared, but intentionally he's
No,
trying to linger.
appearance by filing wakalatnama and not appearing in the court when the matter is taken up is different.
Yes, madam. She's
So CPC takes care of that.
yes, madam. If you
Now, Mr. Marana, one thing is very apparent.
yes,
Why the lawyers are not filing those kind of petitions? Because in some cases you take adjournment. In some cases, Mr. Mahanti takes
if
adjournment.
your lordship will,
In some cases, Madam takes adjournment.
your lordship will find I've never taken any action.
No, that's not the point. That we are not discussing.
Yeah.
Why you have not filed that application? If you are filing an application, the court doesn't pass a order.
Yes, madam.
Then cause of action to come before this court and I will pass a order that you take. Why the matter is. So apparently, some of the cases you are taking adjournment, some of the cases
No such
your
person.
colleague. In this case,
Yes, madam.
where you are the defendant, you take adjournments. Where he is a defendant, he is taking
It
adjournments.
is usual.
And obviously, we do not object to that.
Yes, madam. If you'll, I'm just bringing your lordship's kind attention to the provision 6 of the Family Court Rule 2010, Miller, wherein it has been categorically observed. The procedure.
No, I have, because of 36 only, then you have to tell that 36 is there.
Yes, madam.
Prior to 22, no matter is there. That I asked you.
Yes.
If I made that statement, then very well.
So my limited.
So I will direct that you'll have the opportunity of filing application. The same shall be considered. Parties will cooperate, and the learned courts will try to dispose of expeditiously as possible, depending on the pendency of the total matters. That much I will do. I passed so many orders in these kind of matters.
But it will, since the husband is taking.
Have you gone through the order of Justice Oak, Honorable Justice Oak, when
No, I have not got.
that is a case of expeditious trial,
Yes, madam.
not even a civil matter. You
My
must understand the court, High Court thought that since the trial is still pending, it should be expedited.
Yes, madam.
The court has said, yes, the anxiety is correct, but the earlier case is pending. So how can you distinguish between two sets of
Yes,
persons?
yes, madam.
That is the problem.
That's what I do consider. But since when
then-
the petitioner is regularly coming to the court and taking much more care of her case, in spite of his best efforts, she could not able to get a favorable order from the Learned Court below, madam. This is my only grievance, madam. And due
Mr.
to
Marana, I then have to say that the lawyer is not filing application.
no, madam.
The court doesn't have a discretion, Mr. Marana.
Yes,
This impression being given
agree
that the trial court does have the liberty of the discretion to adjourn matter. There is no such court, not even High Court.
I do consider it a lot.
So if you filed an application, then you show that what was the application and what is the order passed.
No, I have not filed any application, but the statute clearly shows, as per section 36 of the Family Court Rule 2010, my lord, the proceeding before the court shall heard and disposed of as expeditiously as possible, preferably within three months. And in achieving this objective, the rule or procedure may not rightly be rigidly be headed.
Criminal trial in POCSO? Criminal trial in POCSO 1 year.
Again.
Family Court 3 months.
Again.
When the law was enacted, 3 months was fought for. But as the cases are piled up,
but more cases.
if I observe that, I'm asking you. First, you show me that no case, other cases pending prior to 22. Second, you have filed the application, the court has not taken up. These two things are.
Yes,
so leave it there, because I understand why the lawyer is not filing. Because many times you will find here in High Court, for a simple adjournment, both the lawyers are fighting it out. They take it amiss that why he is objecting. This has happened before me. That I could not come from Bhubaneswar, he objected so much, I will not allow any adjournment. I have strong objection. This is the language used. So that is the usual. We live in a world of colleagues. We at times we take a lenient view.
Interest no then taco case at least to get courts na jodi file kar do
Actually say case equally haba katha.
ଆଉ 36 ରେ ମଧ୍ୟ କହିଲା ଯେ 3 ମାସ ଭିତରେ ସରିବା ପାଇଁ ପ୍ରୋଭିଜନ ଟା ମଧ୍ୟ ଅଛି। ତେଣୁ
ସେଇଥିପାଇଁ 36 ରୁ କିଛି କେସ୍ ଡେଭଲପ କରିନି ଇନ୍ ହାଇକୋର୍ଟ ଅଫ ସୁପ୍ରିମ କୋର୍ଟ. What would be the ସେଇଥିପାଇଁ କିଛି କେସ୍ ଡେଭଲପ କରିନି ପକ୍ଷରେ after 1 year what would happen to the trial? Even the bails are granted for 4-5 years because of it is a heinous crime. I'll pass that out. We'll pass out that if you move the, suppose you are moving under CPC or actually CPC.
Again,
There is a very clear provision that when on the date of proceeding the dependent doesn't appear, what order
direction as expeditiously as possible, the matter may be disposed of by the judge family.
cases pending. Because I can't know.
Sorry.
Have you just then you have to
22 ମସିହାର କେସ୍ ହେଲାଣି 3 ମାସ କି 4 ମାସ ଟାଇମ ଦେଇକି
22 ମସିହା କେସ୍ 2020 ମସିହା କେସ୍ ପେଣ୍ଡିଂ ଅଛି 2002 ମସିହା କେସ୍ ପେଣ୍ଡିଂ ଅଛି
ସେଥିରେ ଯୋଉ ଲୋକ ଜାଣି ଶୁଣି ଆସୁନାହାନ୍ତି ଯୋଉଠି ଆମର ଲେଡି
ସେଇଟା that is
and the fact remains, my lord, my husband is a drunkard and he is serving in military department. Whenever
drunkard provision nahi.
ବୁଝିଲି sir, ମୁଁ ଖାଲି I'm just trying to convince
I expect much better articulation from you. I expect a lot from you. Because you are educating me. Suppose I start writing that the husband is a drunkard, the CP. So that's a problem area for the court.
I'm just convincing your
So
lordship.
that is why, Mr. Marana, I'm telling you that I appreciate your concern because the party is suffering. But to give it a legal right that wherever the husband is a drunkard.
ବାଡାବାଡି କରୁଛି ସବୁବେଳେ ହଇରାଣ କରୁଛି ତେଣୁ ସେଥିପାଇଁ ଆମେ ଆସୁ ହାଇକୋର୍ଟ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲେ ଡିଭୋର୍ସ ଆପ୍ଲିକେସନ ଟା ଫାଇଲ ବାଇ ଦି ୱାଇଫ ପିଟିସନର ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲେ 22 ମସିହାର କେସ୍ ଟା ଫାଇଲ ହେଲାଣି ଆସିକି 25 ମସିହାରେ ସେ ଜବାବ ଦେଇକି କେସ୍ ଟାକୁ ଖାଲି ଲିଙ୍ଗର କରୁଥାନ୍ତି ତେଣୁ ମୋର ସବମିଶନ ଗୋଟେ ଡାଇରେକ୍ସନ ଦିଆଯାଉ ଲର୍ନିଂ ଜଜ୍ ଫ୍ୟାମିଲି କୋର୍ଟ ଡିସ୍ପୋଜ ଅଫ୍ ଦି ମ୍ୟାଟର ୱିଦିନ୍ ଷ୍ଟିପୁଲେଟେଡ୍ ପିରିୟଡ
ଆପଣ ଯେହେତୁ ଏକ୍ସାମିନ କରିନାହାନ୍ତି Allahabad. This is the problem. And that is a constitution bench. You must argue. Drunkard husband ki drunkard wife hele bhi, you must argue law.
ମାନେ ସେଇଟା ମୁଁ ସେଇଥିପାଇଁ ମୁଁ ଆସିଛି ମ୍ୟାଟରଟା ଖାଲି ଟାର୍ଗେଟ କରିଦିଆଯାଉ ଶୀଘ୍ର ଡିସ୍ପୋଜାଲ କରାଯାଉ ଯେହେତୁ ସିନ୍ସ ଆଇ ଏମ୍ ସଫରିଂ
ବଏଲ୍ସ ଟା ପଢନ୍ତୁ, read it aloud. My effort to encourage you is that ଆପଣ ବଏଲ୍ସ ପଢନ୍ତୁ. First to arrange you can mark this is a constitution based decision, recent decision. Para 42, can you read it aloud?
Therefore, constitutional court should not normally fix a time-bound schedule for disposal of cases pending in any court. The pattern of presence of various categories, sir.
Just read it slowly. Constitutional courts, this court,
Again.
should not fix time-bound disposal in any court.
Again.
It is a direction that covers everything. Then kindly read further.
Cases. The pattern of pending of various category of cases pending in every court, including high courts in different, the situation at the grassroots level is better known to the judges of the court concerned. Therefore, the issue of giving out of turn priority to certain cases should be best left to the court concerned. The order fixing the outer
Best
limit
left to the-
for the sir,
Best left to the court concerned.
to the court concerned.
Trial court.
Again.
Then
The order fixing the outer limit for the disposal of cases should be passed only in exceptional circumstances to meet extraordinary situation. Sir,
then read for 43 is very important.
there is another important reason for adopting the said approach. Not every litigant can easily afford to file proceeding in the constitutional courts. Those litigants who can afford to approach the constitutional court cannot be allowed to take undue advantage by getting an order directing out of turn disposal of the cases, while all the litigants patiently wait in the queue for their turn to come. The court superior in the judicial hatchery cannot interfere with the day-to-day functioning of the other courts by directing that certain cases should be decided out of turn within a time frame.
Very strong language.
Again.
And they have now interestingly, now
but my case is coming under the exceptional.
that is, so your case is not coming there because I asked you those questions. After reading this, to
Yes.
bring it within 42 and 43, I have to say that no other case is pending. no other lady whose husband is a drunkard is pending. The factual assertion by any court becomes a real troublesome issue. Now kindly look, no, this is, yes. Kindly take down, note down, sorry. This is the matter where this Supreme Court once said, all stay orders shall be vacated within 6 months.
Okay.
So that was recalled by this constitution bench, larger bench, that was the division bench as a larger bench decision. Now kindly just go through this.
But so far the statute is concerned.
No, there's something else.
Right.
There is a supplementing view by Justice, that is very interesting. Justice Mithar, para 57. It's not a minority view, it's a supplementing view, but the language is very interesting.
Sometime in quest of justice,
Slowly, take a microphone.
we
Sometimes
end up
in
doing
the quest of
injustice.
justice,
In quest of justice, we end up doing injustice. ASEAN referring is a clear example of the same. Such a situation created out to be avoided the normal
ought
course.
to be avoided.
The normal course, or if at all it arises, be remedied.
So that's what I wanted to show. Even the court has gone to the extent saying that in the quest of doing justice, we end up doing injustice. 42-43. If there is only another lady whose husband is a worse drunkard or a drug addict, then my entire reasoning falls apart. So that is how that our approach should be legally nuanced. And you have spent sufficient time, so that is how I am spending time with you.
No, fine.
Then can you just read this?
Your Lordship may pass necessary order to them.
I'll pass. I have already discussed. It has now become easier for me. Now read. This is a matter where the court directed expeditious trial. To see this. This is not reported. Maybe I don't know. Last in 47.3.
In paragraph 47.3, on the decision of the Constitution bench in the case of High Court Bar Association Allahabad versus State of Uttar Pradesh and others, this court has held that in the ordinary course, the constitutional courts should not refrain from fixing a time-bound schedule for disposal of the cases pending before any other court.
The next point is important. What they have said. Then the court is what you have read.
Constitutional courts in the ordinary course should.
So that we have already read, because Asian resurfacing just below that.
A direction which can be issued in exceptional circumstances is being routinely issued by high courts without noticing the law laid down by the Constitution bench.
So that I wanted to show you. So that is the difficulty for a read court, because so much has been said to us.
I failed to convince your lordships, but your lordships convinced me.
Basically, the approach is right, that we should not feel defeated. The reason being that if I start attributing this, that her husband is a drunkard, he's beaten every day, then I do not know how many husbands are beating their wives, how many are drug addicts, how many are drunkards, how many are habitual abusers. Even without drinking, normal senses, they torture. And that is the ground in a divorce case. Cruelty is a ground.
Yes.
That's the problem, Mr. Maharana. These are much bigger issues. I'll find out that order. I have past orders, 2-3 orders. Mr. Bose was appearing. Direction for early disposal. Order. ସମସ୍ତ ପଚାରିଦେବେ ଅଛି ସବୁ ଆପଣ ସେଥିପାଇଁ କହିଛି ସବୁ ଅର୍ଡର ଗୁଡା ଯଦି ଆପଣ ରଖନ୍ତେ ତାହେଲେ ମିଷ୍ଟର ଅଜୟ କୁମାର ମହାରଣା ଫର ଦ ପିଟିସନର item 11. The matter was passed over when it reached, and kindly take your seat. I'll take some time.
Yes,
if you have any other case, you can leave, no difficulty.
I know.
I'll pass that order.
Obliged.
The matter was passed over when it reached, and upon Top kar likhuntu, upon being called again, the learned counsel for the petitioner was heard at length. The petitioner is the wife in the marriage. Also, the petitioner before the learned judge, family court Cuttack, in CP number 625 of 2022. The state CP was filed, has been filed by the petitioner wife, section 13 into bracket 1 into bracket I-A bracket closed of the Hindu Marriage Act 55, read with section 7 of the Family Courts Act 1984. As has been stated in the writ application and also submitted by the learned counsel for the petitioner, the petitioner is suffering due to long pendency of the application, long pendency of the CP. I think the rest sector reproduce kariya. I'll pass that order. Yes, next. Yes. Pass over का आप कितना रहना है? It is disposed of. अपन disposed of पर theory question every day ना कौन? तांको पचारी question समझते हो? Disposed of.
अच्छा वो तो होता है
ठीक है
50
petitioner none. The defects as pointed by the SR shall be removed within 10 working days. List orders in the week commencing
33
33-2026. Yes, next.
16
Same order. Same as 15. Defect removal.
17
17 pass over कर दियंतु तो गुड़ा का उठे सार देवे दीटा बड़े after resumption.
18
Wait, please, Your Lordship.
Yes.
Lordship, I am appearing for the opposite parties on behalf of Mr. Rautre. Lordship, we were to file an objection to the limitation petition, but Your Lordship, due to the illness of the opposite party, he has not
You are
been
appearing in
able
this
to
matter.
come.
So let it be adjourned. Out of the nukas.
I request my friend to do.
ଆପଣଙ୍କର assignment ଯଦି ଥିବ ତାହେଲେ ଆପଣ କରିବେ ତା ମାନେ is it possible?
Filed up as is.
No difficulty, sir. But ମାନେ are you comfortable amongst you? I will not compel. I will simply adjourn. I will not observe anything.
You must have gone through the matter. That's the issue.
No, only she is seeking time.
I'm praying for an
She is
adjournment.
only seeking time. Okay, Mr. Ansuman Sethi for the AC for the petitioner. Ms. Charvi on behalf of S. Rautre for the opposite party. The learned counsel for the opposite party seeks for the time to file objection IA. File objection to the IA number 428 of 2023 filed by the appellant, filed by the review petitioner seeking condonation of delay.
Yes.
How much time?
2 weeks, Your Lordship.
As prayed for, the matter shall be the objection shall be filed within 2 weeks. Serving copy thereof upon the learned counsel for the state. List in the week commencing 13/4/2026.
Much obliged, Your Lordship.
Next.
19
Mr. Debasis Patra on behalf of Jagannath Bhuya for the petitioner. The matter was earlier heard at length on 22/1/2026 and was adjourned as sought for by the petitioner. As sought for on behalf of the petitioner, stop. Today, The matter is listed. Adjournment is sought for by the Lord on behalf of the Lord Counsel for the petitioner due to personal difficulty to grant further opportunity to the petitioner. List in the week comments list for orders in the week commencing 30/20/26. 30 ठीक अछि तो? Yes. Yes, next.
Item 20,
Pass over karo.
21,
May I please, Minute?
Please. 21.
My lord, I have the opposite party number father guardian.
Yes, MS Babita Patnaik for the
Yes,
petitioner. Got delay condone hini.
My lord, I have also filed the objection certificate objection on 9th to 2026. I have also served my lord senior friend.
Monday afternoon I got it.
File.
आपण माने we want to go through the objection. माने समय चाहुचंती. Seeking time.
Yes.
And she was in petitioner.
See, upon the petition, upon tale
No petitioner.
He filed the objection.
I am
objection file करछे delay ପାଇଁ.
ଆଜ୍ଞା 9/3/2024 ରେ ଫାଇଲ କରିଛି।
ଯେହେତୁ ତ ମୁଁ 2-3 ଥର ଶୁଣି ମୋର ମନେ ରହିଗଲାଣି। ତ ଆପଣ ଯାହା ଡିସାଇଡ୍ କରିବେ ଆଉ।
ନା ଆପଣ ସେ କଣ୍ଡନ ଟାକୁ ଇଏ କରିଦିଅନ୍ତୁ।
Delay condon.
କଣ୍ଡନ କରିଦେଲେ ସେ ରାଜି ହେଇଗଲେ କଣ୍ଡନ ହେଇଯାଉ। ଆପଣ ପଢିଲେ ଡିସିସନ ଗୁଡାକ?
हाँ पढ़ी
କଣ ନା କଣ କହିଲେ?
My lord Ramkumar Swamy versus Aditya Trivedi. Honorable Supreme Court have granted custody to the maternal grandmother based on the paramount considerations of the child's welfare.
That is the only decision on the point.
No, there are
So which decision I cited? I don't want copies. I am having everything.
There are so many,
including I mean debates and also for foreign case law.
My lord.
Suppose you want to cite Taylor versus Taylor. You want to read. You should read. My effort is there to encourage you to read. So you have to prepare a case where in your case, in the facts situation,
my lord Ramakumar Swamy.
You will not listen, that's the problem. You are not listening, that's the problem. Anyway, I am condoning delay.
My lord.
ଆପଣ ରାମ କୁମାର ସ୍ୱାମୀ ଯୋଉ କହୁଛନ୍ତି, you must read the facts of your case. Try to find out what are the cases against you and what will be your argument. And you will definitely win a case. You don't have to tell the court. You will get the order.
My lord.
So you have to develop that way. आइएटा कितने condemnation है?
One is
15 of 2025.
Another is
The IA has been filed seeking condonation of delay in filing the GUAP. Hard Lord Counsel for the condonation of delay of 540 days in filing the GUAP. ଆପଣ ହଉଛନ୍ତି କିଏ? ଆପଣ ହଉଛନ୍ତି for ନିରୋଧ କୁମାର ମହାରଣା is?
Nirat Kumar Maharana and
କଣ ସେ ବାପା ପୁଅ ମାନେ
grandmother, grandfather.
କେତେ ଟଙ୍କା ଦେବେ 542 ଦିନ ପାଇଁ?
My lord, what I'll say. Actually, they will not pay. I will pay.
ସେଗୁଡା କରନ୍ତୁନି। ଆପଣ ତାଙ୍କୁ ଫିସ୍ ନିଅନ୍ତୁ କେସ୍ ସେମିତି ହେଲେ କଣ ଆପଣ ଚଳିପାରିବେ? ହବନି ସେ ଶସ୍ତା ବୁଡିଯିବ ଆପଣ ଶସ୍ତା ବୁଡେଇ ଦେବେ।
I am doing till 4 years.
That is how you are wearing your robes. You have to respect your profession.
Yes, I know that.
I was told by the senior
But that reason.
I in the bar by a senior that I have heard everyone has had this, I think. He used to tell this that whenever you start in the morning, he used to take 100 rupees from his mother as fees. Returning, he will return 200. But to start the day for the work, for the day's work, he will take 100.
Yeah,
but after coming back, he will hand over 200 rupees to every time the mother will get a 100 rupees extra, but he never did it free of. Because you should not do any case free because you are independent. You cannot identify the cause of your client. Unless you are appearing in person. 500 rupees ତାଙ୍କୁ ଦିଅନ୍ତୁ at least 542 ଦିନ କିଛି କାରଣ ନାହିଁ ଆପଣ କଣ ଡିଲେ କଲେ କାରଣ it's a case of custody ଆପଣ ଯୋଉ ଦିନ ଜାଣିଲେ କେସରେ ସେଇଦିନ ଆପଣଙ୍କ ନଲେଜ ଥିଲା
ସେ appear କରୁଛନ୍ତି
ହଁ
ମୁଁ ସେଠି appear କରିଛି actually ଆମେ କିଛି notice ପାଇନୁ ସାର୍ କୋର୍ଟରୁ
ସେଇଟା କହିଲେ କେମିତି ହବ ଆଜ୍ଞା ସେଟା that's the again problem ଶୁଣୁଥିଲୁ ଜଣେ କହିଲେ ଆଜ୍ଞା ସ୍ୱାମୀ ମତେ ମଦ ପିଇକି ବାଡଉଛନ୍ତି ମୁଁ କେସ୍ ଜଲ୍ଦି ଡିସ୍ପୋଜାଲ ହଉ ସେଇଭଳିଆ ପ୍ରୋବ୍ଲେମ ଆପଣ ଯଦି ସେଗୁଡା କହିବେ that is not legally nuanced. Can I reflect those things?
No, okay, I have already appealed.
500 rupees दियंतु
हाँ देवी.
Which is very minimal amount in today's cost. I mean today's prices.
Minor. I will give. Thank you, Devi. Na court re devi.
One of another senior very interesting. After taking 500 rupees cost, he had he said that to let us see. So there was a bill of 1,000 rupees, and the 1,000 rupees was paid by the other side counsel. These are exact stories I am telling you. So that also you can do.
Actually,
the dinner bill of 1,000 he will pay 500. That can always be done, but that cannot be the order for condonation of delay. 1,000 bill was paid by the present president, Mr. Manoj Mishra, senior advocate. 1,000 or 2,000, I don't remember, but the cost was 500.
Actually,
filing the, you take your seat, I'm dictating the GUAP. The IA has been filed supported by affidavit. It is submitted by the learned counsel for the petitioner that sufficient causes have been shown for condonation of delay. The learned counsel for the respondent refers to the objection and prays for and opposes the prayer for condonation of delay. Considering the fact that the appellant is grandfather of the child, grandfather and grandmother. Appellants are grandfather and grandmother of the child. Is directed that the delay of 542 days shall be condoned subject to payment of cost of rupees 500 to the opposite party. The amount shall be paid to the learned counsel for the opposite party and the receipt shall be filed or you pay to the advocate's welfare fund subject to payment of cost of rupees 500 which shall be paid to the Orissa High Court Advocates Welfare Fund. The receipt shall be filed within 3 working days. ଆପଣ ବାହାରେ ଡିପୋଜିଟ୍ କରିକି ରିସିପ୍ଟଟା ଫାଇଲ୍ 3 ଦିନରେ କରିଦିଅନ୍ତୁ. List for admission in the week commencing. The appeal shall be listed for admission in the week commencing. 20/4/2026. The proceeding before the execution case number 15 of 2025 arising out of CP case number 22 shall be ବର୍ତ୍ତମାନ ପିଲାଟା କୋଉଠି ଅଛି?
ଗ୍ରାଣ୍ଡମଦର ପାଖରେ ଅଛି.
ତାଙ୍କ ପାଖରେ ଅଛି.
ହଁ ଅଛି. ମାନେ ଗ୍ରାଣ୍ଡଫାଦର ମାନେ ମ୍ୟାଟର୍ନାଲ
ଏକ୍ସିକ୍ୟୁସନ କିଏ ଫାଇଲ କରିଛନ୍ତି?
I am the father.
ଆପଣ ଏକ୍ସିକ୍ୟୁସନ ଫାଇଲ କରିଛନ୍ତି.
After the
execution shall be the execution case number 15 of 2025 arising out of देखिए ଆପଣ लिखि परिबे already अछि 2/2 रे अछि 2/2 order रे अछि shall be adjourned beyond अपन केते तारिख देले से बारी केते shall be beyond 20/4 shall be adjourned beyond 27/4/2026 to a date as would be convenient to the learned court in season of the matter.
hearing and suvidhan.
For admission matter को suppose by listing 80 matters, it is not happening. अपन तो सब मैटर रे अटकिले कोठी केते टका दबे सिक्यूरिटी पाई 2 घंटा आर्गुमेंट होछ. So obviously that reflects on the entire list. तापरे जदि हियरिंग भी होला से आजन होला परे हियरिंग होला परे no headway is made. The composition of the list actually is important. This is not a list where you can score so many disposals for hearing. Hearing helan. Substance कौन achieve it? 10 minute रे किसी सेमती है. So we have to draw a balance. I'm not blaming. Please don't think that way. I'm not blaming anyone, either of you.
No matter.
Rather, 500 टंका से राजी है. I mean, at least you did not object. अपन जो कहते थे मुझे 500 बॉयज दिनों किसी explain करना है कि no reason has been shown. You could have, but since she didn't say, you said that let the delay be condoned, so I condone.
My lord, actually, this delay come unfortunately. Can I filed
Section 7 Limitation Act Section 5 unfortunate किसी नहीं.
नहीं
that is decision justice पढ़न्तु हमर स्टेट रा गोटे अछि.
This was filed.
That is sufficient cause. अपन once you have taken a plunge into the profession, be serious.
नहीं 19
that will help you in future.
24 रे फाइल हेतला केस टा 19 माने डी माटा नंबर 2976 of 24
filing is not filing.
तो सेटा पूर्ण फाइल
unfortunate, that is fortunate. So that माने unnecessarily cases are not piled up. अपन defective file करी कहबे जे एटा unfortunate.
नहीं माता हे जाइतला.
Anyway अपन तो दे दे कर. अपन vegetation right कहीं फाइल करना है. When you are seeking custody in a minor child, always first go for vegetation. Vegetation is very simple. So that will develop your relationship.
ଆମେ ଯାଇଥିଲୁ ପା ସେ ଦେଖା କରି ଦଉନାହାନ୍ତି.
ଆପଣ ତାଙ୍କ ପାଇଁ ଫାଇଲ କଲେ ଏଟା reproduction disposal.
The grandfather wants the visitations of the father.
Reproduction before the grandparents. I will dispose of the reproduction filed by the father, the visitation right before the parents.
चाहूचु कहीं कि ना झीटा तुम बापा को जानी
मैडम कहले आपण फाइल करो ताइल अलाउ
करंतु विजिटेशन करंतु कहीं कि ना मु भी चाहूतिली जदी ग्रैंडमदर चाइल्ड और फादर
let us see
गोटे मेडिएशन हो
तापर आपण से बीट जी मिस्टर महांती को एंगेज करिवे
नहीं परिबे नि कहीं कि ना he has not
so let us see
my lord
अरे एटा सरला कर let us spend some time in somewhat for এটা item
22 acknowledgement.
So BK Naik for the madam, it is a you take it seriously. Both of you talk to each other.
Yes.
So you will file the visitation and contact rights. You convince your what will be the condition of you work out. Court's request is that visitation केमिति हबो केते बेले हबो कोठी हबो both of you please settle.
28-25 रे मु जाइथिलु हम रिलेटिव हम
आपण सबुठी दुखड़ा सुनांतुनी. The lawyer should find out ways to achieve a goal. आपण दुख कहउछन सी तांको दुख कहउछन that is not none of your interest also. You work out a solution. This is human relationship. आपण मैडम के साथ कथा होंतु what will be the terms and conditions settle करंतु come back to me. I'll pass that order.
God bless.
And
request my lord. My humble request, please. I have some submission to listen, my lord.
बर्तन इतरे कोन होबो
नहीं मुख से जो
केस में मेरिट रे किछि नहीं. आपण सुनत आपण डोंट गेट बी फोकस्ड ऑन योर वर्क. आपण को डिले कंडीशन फर्स्ट पार्ट आपण अचीव करि गले सरला. तापरे नेक्स्ट पार्ट हला जे आपण vegetation or contract rate दियंतु which is a very basic fundamental right for the natural guardian. Yes.
Obviously.
So we can make free for the petitioner. The matter was heard at some length on 5/2/2026. order dated 5/2/2026 para one time. Repeat hellas na court no repeat. Today the matter being in the list is mentioned by the learned counsel for the petitioner. He files memo of date which indicates thus. Na quote kar dere. The memo shall be taken on record, scan copy be updated. In view of the above, the petition starts disposed of. Yes, please.
Item 56.
Yes.
Final disposition one. Kindly take up next week file kariye written.
Any matter wherever you want a date after notice hearing matters, he will give you.
Bye.
Yes.
Date
No difficulty.
Bye.
But no specific order is being passed, so it will save time. Adjournment in computer becomes much easier. So you take a date. Sir. 29 lekhantu. The matter being in the list was mentioned by Sri G. Banji, learned counsel for the petitioner.
Recording in progress.
Matter being in the list under the heading for admission within single court. And accordingly, stop. The learned counsel for the petitioner was asked, he should intimate the learned counsel appearing for the opposite party as the matter is listed for after notice hearing. On resumption of the proceeding after the lunch break, recess, Mr. J. Pandal, learned counsel for the opposite party, submits that the matter was mentioned without informing him, and with much efforts, the matter he could mention the matter and get it listed. The objection of Mr. Pandal, learned counsel, is noted. Mr. Pandal kuhuntu.
Next week, we accept 19. Anyway.
List in the week commencing 23/3 Specific there is some difficulty because once it is specific, then suppose for some reason
actually
due
to pendency of this week.
Whatever listing the alga jinso katha hoche week commencing hele suvidha hoche, there is to get all the matters listed at least during the week. Otherwise a single day's miss, suppose one matters is not getting listed due to the list is full, then it cannot be listed on the other day. Then it is mentioned. Then it goes back to the listing section. All these things can be little bit alleviated by making it in the week commencing. And suppose second was a working day, I direct listing on second. Now it is declared holiday. The matter cannot be listed. It cannot go to 5.
Yes.
So if it is week commencing second, then it was 12, 5, 6, 7. It could be listed. Only last two, Mr. Pandal on counsel mentions the matter. On resumption of the proceeding, so and so. So Pandal on counsel mentions the matter. Yes.
Answer item 10.
My lord, I am for the petitioner, my lord. I prefer the present revision challenging the order dated 27 January 2026 and order dated passed in TNC number 31 of 2025 and order dated 4/11/24 passed in CNC number 12 2024, my lord. The short case is that, my lord, the petitioner are the sons of the opposite.
Mr. Devata, this cause of action can join together, separate orders being challenged in one application?
No, my lord, what has happened? Originally, an 127 order was passed. The first case is pertaining to 125.
Have you challenged that? Have you challenged that?
No, against that order, I prefer.
No, you don't listen. If you don't listen, it cannot register in your mind. The question is very specific.
Yes, my lord, I understood.
You are challenging the order 2026. In the pretext of challenging the subsequent order. When you have not challenged the first order and the subsequent order is based on that, how can you do that?
No, the first order is, my lord, passed under section 125 of the CRP.
So have you challenged that? Did you challenge that? That's the question to you.
Yes, my lord, that was challenged.
By which application?
No, by under section 127 it was challenged, my lord, before the Law and Family Court. And the Law and Family Court reduced the amount of maintenance.
So that is that is now res judicata.
No, my lord, how it will be res judicata?
Yes, it has to be. It has to be. You are satisfied with 127 order.
No, I was not satisfied, my lord, because the Law and Trial Court.
Listen, the speech is overlapping.
The speech is
you appear physically because this process cannot continue.
No, my lord.
127 order have you challenged subsequently?
No, this is the first challenge, my lord. I am challenging the 127 order. And because the earlier order was an
125, you have challenged 125, show me the pleading.
No, my lord. In the present revision, I have assured both the order, my lord.
Sir, that you cannot do. You have to, in a revision, you cannot couple together all the cause of action. Whether if you are agreed by 125.
My humble submission, my lord, is that
question is 125 order, you challenge which petition you show me that. I'll see, I want to see that before taking up of the matter. Well, in fact, while taking up of the matter.
All right, my lord, I will amend it then.
No question of requesting for amendment. No, it is not at your choice. 125 order, when you have challenged, you are saying you have challenged in 127.
So, originally, I filed the.
You saw that.
And that was withdrawn with the leave of the court, my lord.
Sir, you saw that.
Originally, I had filed.
It is a matter of speech. It is not a matter of speech of both of us. It's a matter of pleading. You have to show me in which order, by which petition you challenge 125. I have to see that.
No, my lord. Before this court, in a separate RPFM, originally I had assailed that order of 125 order. And after taking leave from the honorable court.
Sir, you are just going on a speech.
No, my lord.
Well, now, at least much persuasion, now you have said that you challenge 125.
No, 127. Both the order I have assailed, my lord. And now my grievance is confined. No, my lord.
Can you follow India?
My lord?
ଆପଣ ଓଡ଼ିଆ ବୁଝିପାରିବେ ନା ଇଂଲିଶ ରେ କହିବେ ଆପଣଙ୍କୁ?
ଓଡ଼ିଆ ବୁଝିପାରିବି ଆଜ୍ଞା.
You have to wait till I complete my question. Don't continue. It's like a commentary. First order is 125 order is dated.
That was challenged before your lordship.
It is impossible, Mr. Devta.
No, my lord. Earlier case number. My lord, let there be a short adjournment, my lord, on the next.
No. This is not a. I will call the matter 4 times, then I will adjourn it. This matter has been again and again passed over, and this is the 4th time it is being called.
No, my lord, in the earlier.
You have to be taken with your brief. What is the order? 125 order is dated.
Sir, mo 127 ro jo order ta 27 January.
Yes, sir, 27 रे केमती order होबो mo? Pouchonti at you raise and experience at the bar. However, 127 is the original order.
Original order was originally assailed before your lordship in a separate RPFM
Give the number. So first you tell the RPF, so the order in the 125.
Just I am submitting, my lord. And that was withdrawn with the leave of the court to approach the Law and Family Court in a petition.
Sir, first you are not telling the date, you are giving the speech. For the last 10 minutes, I am struggling with you to tell the date and case number 125. What is the date of the order and what is the challenge?
Yes, the first order was
every time I ask you this, you are saying something else.
No, the first order was SL in RPFM 132 of 2025.
So now you listen to the question and answer. What is the date of order in 2025? By which court?
Yes, sir. Just 1 minute, my lord. I am submitting. You can now do it. My lord, your lord, this order was disposed of by order dated 1/9/2025.
Sir, which is the first order passed by the court? Which court? Under section 125 CRPC.
That order was passed on 4/11/2024, my lord.
4/11 to 2024, 10 times. In which application? Where you have disclosed?
That RPFM 139 of 2000.
You file affidavit, keep giving all the dates and the details.
Yes.
Or else I will dismiss the application on this court alone.
I will file an affidavit to that effect.
The petitioner is before this court, challenging, seeking revision in one revision application. As many as 3 orders. That is, order dated 4/11/2024, passed in CMC number 12 of 2024, passed by the Honorable Judge, Family Court, Sambalpur. And order dated 27/1/2026, passed in CMC number 31 of 2025. The Honorable Counsel for the petitioner, the matter, since no one appeared when the matter was called, it was urgent. It has been called thrice over. The Honorable Counsel for the petitioner appears on the third, when the matter was called for the third time, after the resumption of the proceeding post lunch. Resumption of the proceeding of this court post lunch. He has repeatedly asked how the petitioner can challenge 2 orders in one revision application. It was further asked in the context of the present adjudication, which is the order passed under section 125 CRPC, by which court and what is the date? Since the facts are not very clear, as they have not been mentioned in the application, the petitioner shall file affidavit giving the details of the earlier cases, provisions under which they were filed, name of the court which passed which considered those matters, date of judgment oblique order, whether they were challenged in any proceeding earlier before any court, including this court. Such details shall be filed by how much time, sir?
Within a week, my lord, I will file.
Such details shall be filed as requested by the Honorable Counsel for the petitioner within 10 working days. The matter shall be listed in the week commencing, listed for fresh admission in the week commencing. 33-2026. From the today's proceeding, it is apparent that there is some difficulty in explaining the facts when the learned counsel is appearing in VC.
My lord, in the early hour also I crave leave to make a submission because of the virtual court was engaged, both the court were engaged in some other matter. That is the reason, though I was present in the virtual court, I could not address my lord. In the early hour when the matter was...
Sir, that is a very good explanation for not appearing. So I have no court, I think I have in my practice across the country, wherever, that is, I have never seen the matters with the adjourned for 3 times. So that I have taken care of.
No, my lord,
so have I asked you that why you did not appear? But I have to record. I have to record that, yes, because a court is not to call a matter thrice.
Yes, ma'am.
Understand?
Obviously, my lord.
So to keep, so I have to be, to that extent, I have to be, I mean, I have to mention that. I didn't ask you. But my problem is that I have heard you several times.
Yes, my lord.
You are always ready with your facts and figures. But somehow that today I have not been able to convey even the first point. So maybe there is some difficulty in, exchange of our ideas in VC. Or like it?
By the next date, I will submit.
And getting response from him, he may consider appearing in physically before this court. It is up to you. I am not asking you because this is a facility, but at times I don't know what is happening. When I am asking you one question, it takes almost 10-20 minutes to get through. Yes.
That's our item 17.
Like it is the third take.
The second.
None appears for the petitioner, though the matter is called twice over. Petitioner non लिखिए. None appears for the petitioner, though the matter is called twice over, once when it reached, and thereafter upon resumption of the proceedings of the court post lunch. Stop. Earlier on 23.02.2026, none had appeared for the petitioner and it was adjourned, granting further opportunity to the petitioner. The matter shall be listed in the week commencing. Kebe as per you? Ite lama date kale lama kono. The week commencing 33. ठीक है 6-4 करंत आपण कहउछन 6-4-2026. Next date of listing shall be intimated to the learned advocate appearing on behalf of the petitioner. It shall also be mentioned in the cause list that the matter shall be disposed of. Opening line lekhantu. The matter was presented before this court on 9/3/2023. Thereafter, it has never been listed till 23/2/2026. Yes. Next.
That's our item 20.
जो दिन presentation date है लिखना थी. The matter was filed before this court. वो दिन किਵੇਂ फाइल है? How is it possible? The matter was filed before this court on 22/12/2025 and registered on 27/12/2025. Today, none appears for the petitioner, though the matter is called twice over. Earlier, on 15/1/2026, none had appeared for the petitioner and the matter was adjourned to grant further opportunity. Stop. Thereafter, the matter was again listed on 2/2/2026. None had appeared, though the matter was called twice over. Stop. It was adjourned on the said date to grant further opportunity. Para. The matter shall be listed in the week commencing 6/4. 6/4/2026, Priestess for orders for 6/4, indicating that the matter shall be disposed of. Copy of this order shall be the next date of listing, as well as the copy of this order shall be communicated to the learned counsel for the petitioner. Yes, please. Next.
Item number 23.
The matter is listed for admission. Cyril Jauchand. The matter is listed for admission, hearing. For admission, the single court error. Like that. Petitioner, ऊपर लिखियो appearance से petitioner done. 23 रे Mr. Sethi, you are there.
Mr. Pradeep Sahoo service. Well, he gave me the files for 21 and 22, just in case.
Mr. Anshuman Sethi on behalf of PK Sahoo for the AC. Mr. Anshuman Sethi AC on behalf of PK Sahoo AC. 23. Anyway, did not because no one is appearing, so I can your name can be recorded. Yes. Anshuman Sethi AC for the. None appears for the petitioner when the matter is called. The matter was presented before this court on 4/6/2000. On 13/6/2016, copies were directed to be served on the learned counsel for the state, and interim orders were passed. Thereafter, the matter was listed before the coordinate bench. You take your seat. The matter was listed before the coordinate bench on 8/9/2025, on 14/11/2025. And on both the dates, prayer was made for adjournment and the matter has been adjourned. An interim order was directed to be continued. The matter shall be listed in the week commencing to grant further opportunity. For admission, order sorry. 24. So, orders fresh admission agua rakhiu. Will be listed in the week commencing 24 to grant further opportunity to the petitioner. The next date of listing shall be intimated to the learned counsel for the petitioner.
Item 24.
Single matters.
I think the same. Learned counsel is also same.
Yes, sir.
Again, presented should I same order kar debe thale? None. Mr. Anshuman Sethi for the additional standing notes.
Item 25.
Mr. Sangram Jena for the petitioner. 23, 24, 25, all are Mr. Sahoo's matters.
25 is mine.
Okay, 25, Mr. Sangram Jena, then 25. Mr. Anshuman Sethi, Additional Standing Counsel for the opposite parties, 1, TO2, 4. So KK Swine, along with Mr. JR Khuntia, OP number. For deviator. Adjournment is sought for on behalf of the learned counsel for the petitioner due to unavailability of the learned senior advocate. To take your seat. The learned counsel, Mr. Swain, for the aviators, seriously raises a grievance regarding adjournment for grant of adjournment. He submits that the caveator oblique opposite party had was successful before the learned education tribunal, and in the present matter, interim order is continuing against the caveator. The objection of the learned counsel for the caveator is noted. The matter shall be listed in the week commencing 6/4/2025. Interim order passed earlier shall continue till the next date. Interim order dated जब दी परियो नाले passed earlier कर देते ठीक है. Second matter लिखिए WPC 8340 of 2022 8340 2022. Mr. Sangram Jena, same rival. The caveat touching, I'll just let you know. Caveat. Case intervener. Mr. Anshuman Sethi for the UP1 TO2 4. The KK Swine for intervener. The matter is listed with the connected writ petition WPC number 9869 of 2019. In view of the order passed in the said writ petition, the matter shall be listed on 6/4/20 in the week commencing 6/4/2025. ठीक है जी.
27.
Mr. Naresh Chandra Jena. मेमोटा देले ना आपन को. मेमोटा आपन देले थे.
Instruction.
Yes, yes. The Naresh Chandra Jena for the petitioner. Opposite party. Blank. Party blank. The president चलेगी mention में.
No.
The learned counsel for the petitioner files memo of date which indicates thus. The memo shall be the memo along with photocopy of the order dated 18/1/2023 passed by the Learned Judge Family Court in CP number 304 of 2017 shall be taken on record, scanned copy be updated. In view of the dismissal of the CP number 304 of 2017, out of which the present WPC arranges, nothing survives for adjudication. So, the writ petition stands disposed of. Twenty-eight. ଆପଣ ମନେ ରଖୁନାହାନ୍ତି ଆଉ ଆପଣଙ୍କ ଜୁନିୟର ଆସିଥିଲେ ତାଙ୍କୁ ହେଲା ଲେଖିବା ପାଇଁ ଆପଣ ଭଲ ମିଷ୍ଟର କମଳାକାନ୍ତ ସେଠୀ and Mr. ଜେନା ବି ଆସିଥିଲେ ଦି ଜଣ ଦିଥର ମେନସନ କଲେନି ଆପଣ ଦି ଜଣ ଦିଥର ମେନସନ କଲେ ତା ବି ଭୁଲିଗଲେ ଆପଣ ତ କମଳାକାନ୍ତ ସେଠୀ on behalf of Mr. S. Mahapatra for the petitioner. The matter is listed for hearing under the heading for admission. Stop. Learned counsel for the petitioner mentioned the matter at the beginning of the day's proceeding and sought for adjournment. On 17/2/2026, the following order was passed. The learned counsel for the petitioner was asked to take note of the fact that by the impugned judgment, monthly maintenance was directed to be paid by the Learned Judge Family Court Dhekandal under section 125 of CRPC at the rate of ₹12,000 in favor of the wife in the marriage and ₹8,000 to the child born from the wedlock. It was also indicated to the learned counsel for the petitioner that the said award is in the nature of a money decree in view of the judgment rendered by the Honorable Supreme Court in Rajneesh versus Neha. And for sustaining challenge to the judgment, the petitioner must secure the amount before this court. He has to disclose stuff. He has to disclose before this court the amount already paid and the amount due to be paid towards the due to be paid to the opposite party, not towards. Due to be paid to the opposite party towards monthly maintenance. Opposite party लिखिए रमणी रंजन महाती लिखी दियो पर तापर लिखिए when the matter reaches the order is passed, the above order is passed. Matter shall be listed in the week commencing 13/4/2026 for orders.
item 29.
29 टा आपण ऑर्डर लिखले ना 29 से ऑर्डर टाको आपण रिप्रोड्यूस कर देबे तो मेंशन न करी की ताको एवढा कर देबे the matter is mentioned when the matter reaches jana J Panda Gyanananda Panda appears for complete कर देबे Mr. Ansuman Sethi additional standing counsel 29 yes next
30.
May I please?
yes please
My lord, the brief has been transferred. I have entered my appearance.
You are appearing for
Petitioner, my lord.
Mr. Wakalatnama is to be filed.
No, transfer to me.
Wakalatnama kind.
Filage, recorded.
आगुरु की अपेयर करथले
आगुरु से
प्रतिभा नायक के विश्वास
आगे से
के भी ना आपण कौन गुडी देले
से
यो बिकम संजू सैमसन
अपेयर कर ले
कम से कम 10 जनकर ना আছে
आगे
आपण जणे ता 10 जन गुडी देले
लास्ट रे मोन हाटे रोक दिछन
सुंदररंजन दास
आगे
अधिकारी प्रधान
के ना
ओ दे सी तांकर
से बरगड़ से मैंने अपेयर करथले वर्चुअली तापर
1 2 3 4 you are the fourth set of counsel
आगे
this is regarding a muslim marriage
yes muslim marriage ने इट से आमची कोड सिविल सूट टा ट्रांसफर करली वो हस्बैंड एंड वाइफ डिस्प्यूट माय लॉर्ड
so Soumyaranjan Das Learned counsel for the
ये तो
petitioner आपण वकालतनामा केवी फाइल केलं मिस्टर दास
माय लॉर्ड लास्ट फ्राइडे मत के लेते
petitioner there so the 9 year
ओ तसडा आसीनी होते नाही की Soumyaranjan Das Mr. Soumyaranjan Das Learned counsel submits that he has filed अचिता भितर कोड आपणकर स्कैन ही नहीं ना कौन रंगटा सागुआ आपणकर तो कहीं सागुआ किसी नहीं सब धड़ा कर देछन ओ ब्लैक एंड व्हाइट अच्छा अच्छा केबे को कलर होतला आपणकर the learned counsel for the petitioner Mr. Das Learned counsel submits that the petitioner has obtained change once again for the fourth time and he has now entered appearance on behalf of the petitioner upon the learned counsel who was appearing earlier giving consent to engage any other counsel. Stop. Name of the learned counsel who were appearing earlier for the petitioner shall be deleted from the cause list as well as the case brief. Stop. The name of Mr. Soumyaranjan Das, learned counsel, shall be indicated in the cause list as well as case brief if not already indicated. Stop. All right, Mr. Naik is there.
Mr. Naik.
So Pavitra Kumar Naik should have Roibo. Upon appearance for Dakini was Pavitra Kumar Naik. Yes, there is. Yes, Mr.
My lord, here the petitioner lady is seeking transfer for civil suit case number 45 of 24 from civil just
cause of action. My lord, section 9 cause of action of the filing of the suit.
My lord.
So what is the section 24? This is application under section 24.
My lord.
So if you read section 24, it is convenience of the parties.
My lord.
So it can't be the only the so
no problem. My lord.
See, problem will be there because law anyhow any case is a problem.
Problem here
but it has to be legally tenable ground for 16. So what is she? She is a dependent petitioner. What she is?
She is an advocate.
Advocate, why she will seek?
My lord, actually problem is the matrimonial case.
Conducting counsel. Advocate in the sense?
When the party, the
petitioner is the profession is
no, kindly question is not that. I never asked that what is her profession. I'm asking the petitioner before this court, what is her status before the trial court? Whether she is a defendant, she is a applicant, she is a petitioner,
The
respondent.
trial court was the defendant.
Defendant.
If how it can be transferred? It cannot be.
The problem here is, my lord, dispute between husband
The
and
problems,
no, coach.
it has to have some legal consequence. Mr. Das, let us not spend time like this.
No, I'm telling.
So you have to show, no, this is civil suit for under Bulla's principle of
No.
Is it
If
suit
for
for-
a piece of property,
so it's a
there is a
suit.
quarrel between husband and wife.
Declaratory suit.
Yeah.
Declaratory suit.
They were resolved.
So now the territorial jurisdiction is admitted before the trial court. Pecuniary jurisdiction is before the trial court.
No, so the land,
That which provision or under any decision you can show that where this court can interfere and transfer the application.
the land which is under challenge here, my lord, it is in Borgar. It belongs to the petitioner and her mother. After the matrimonial dispute arises between husband and wife, matrimonial case is pending in Borgar. For dissolution of marriage.
You want to win the suit or lose the suit?
I definitely.
No. This I have been finding very difficult to understand actually. So you want to say that lack of territorial jurisdiction, you are a defendant.
Yes.
You are saying that lack of territorial jurisdiction on the part of the court trying the suit. You take that plea, suit will be dismissed.
My 100.
So you want to lose the suit?
No.
Then
140 kilometers from Cochin.
140 or
Yeah.
So you have to show that there is a distance limit in CPC. That when the has territorial jurisdiction, then distance will be measured and the court's foot has to be tried.
Madam, some date trial.
No, sir. Sir, this is the way the time of the trial. Sir, that is how the sir, you are making way for the fifth counsel. You have to keep track of this kind. So that is one of the reasons that many of the seniors did not accept any transfer brief.
No.
Every day one new counsel is engaged, then there is no end to it. We can't waste time like this.
Seti again, this is the
Sir, that is the base ground you can take before the trial court. So that
our lady does he again 140 kilometer jiba se
lady जीवन से तो CPC रे नहीं है. So सेटा तो अगर कथा अपन after Sunita Williams has gone to school, please don't argue this.
Matrimonial case पे it pending ଅଛି बरगड़.
सेटा ଗୋଟେ ନୂଆ jurisprudence ଆପଣ develop କଲେନି ସେଟା ଗୋଟେ ଯାଇନି. ଯୋଉଠି ଥିବ civil suit dispute ସେଇଠି ହେବ matrimonial case. ସେଟା section 19 ରେ ନାହିଁ. So let us not go enter into that. He is smart enough to appear next time. This whole effort of we every day pounce upon our trial courts that you are not disposing. And we are keeping our matters pending from 2024. A property suit, you are the defendant. You are saying that the court is not having territorial jurisdiction.
No, jurisdiction kotha
going, sir, how can we sir, sympathy for the lady, CPC re achi.
Humanitarian ground.
Humanitarian court seta achi. I may be inhuman. You must understand that the judge, inhuman judge, doesn't have a choice but to follow the CPC. So he will follow him. He has to be human.
Seti golabi taku.
You tell your client the judge is inhuman, so he is not listening. If the CPC says that humanitarian ground has to be considered, it has to. It can't be empty formality wasting time of both courts. The petitioner is the defendant in the suit, CP number 45 of 2024. सूटर पेस्ट कोडे गला
सूटर मते भी कभी दिस सूटर प्रेयर भी नहीं
मते दियंतु मु सेग्रो रे आज डिसमिस कर देबी मु आगे बिना प्रेयर रे मोर एबिलिटी नहीं मु तो आसो चिनु मान
मैलो में केपी टू समाधान
से ग्राउंड रे डिफेक्टिव रू एटा
ମୁଁ ଦେଖିନି ମୁଁ
टाइटल सूट मैटेरियल एटा फाइल कले टाइटल सूट रे बुझी पानी एटा को डिक्लेरेटरी इंजंक्टिव कोन सूट बुझिया पे देखला को
रिसेंटली अपेयर करछि गोटे डेट
नहीं सर आपण रिसेंटली अपेयर कले 24 वर्ष गोटे केस पेंडिंग अछि तार
मो
किछ नाही
आई अंडरस्टैंड
सो नाइक he has his style. He'll say that I don't have anything.
Just before Lordship asked me, I requested him to give me the answer.
So he was ahead of me. He is also searching that what is the suit. The suit is there, but injunction, so declaratory relief, कौन सी का?
There is suit for the मुझे सेवटा.
आप लोग जानना थे.
मुझे ताको just पचार दिले जे.
This is.
I do understand, man. My lord, my client wanted.
I can't complete the sentence even. Copy of the CP that has been annexed to the petition conspicuously does not contain the page 5 of the plaint, which contains the prior paragraph. Accordingly, this court is not in a position to understand.
Page 4 टा नहीं.
पछु पसी है जी.
Page 4 नहीं. The prayer portion टा page 4 रे.
All your counsel आगे फाइल को कोचुम.
आपण को भी कर सकले.
अच्छा I will
page 4 and 5.
I provide it, man.
Page 4 and 5 exactly लिखिए. कोटा नहीं तळे अछि देखो.
ने गोटे जे स्थिति ऑफ द लैंड इज तळे.
In fact, I was almost completing the sentence when I lost my way, so I am now confused. Pages 4 and 5. This according to this court is not able to. This court is not in a position to understand the nature of the suit vis-a-vis the prayer made therein. Both the Lord Counsel for the petitioner submits that since he is the fourth counsel engaged by the petitioner, he has some difficulty in getting the brief, and given some time he will file complete the copy of the entire plaint before this court. Correct. The Lord Counsel for the opposite party submits that he has not also been provided with complete pages of आपण भी staff reporting करना जे काहे 20% पेंडिंग रहबा आपण आपण तो प्रथम दर कहथिले सेटा it would have been taken care of. कौन लिखले? To all the pages of the plaint filed before the trial court. As paid for by the Lord Counsel for the petitioner, the matter shall be the further 1 week time granted to how much time?
1 week time.
The copy of the plaint filed before the trial court shall be filed within 7 working days. Copy shall be served on the Lord Counsel for the opposite parties. How को पेज नहीं देखूं एकाथरे गोटे ऑर्डर में
मोर कति 4-5 पेज से 2 पेज नहीं.
2 पेज नहीं ठीक है. Para. Though the pages 4 and 5 are not there, but it is stated by the Lord Counsel for the parties that suit involves कौन रिलीफ कौन चाहूँ इंजक माने आपण भी केस कर परिबे
सी फाइल होची हां सी फाइल
ओसे माने आप कौन रिलीफ आपण चाहूँ से
फर्स्ट टाइम लिस्ट ला
आपण भी जानना बोलो तो जज काहे जानिए जो डबल तो ये नहीं मन
नाइस
सो कौन लिखे
वो तो मेरे को तो नो विषय
a property that creates more problem than solution. The matter shall be listed in the week commencing. Kebe chahuchen Mr. Das?
My lord, 30th.
30 नहीं करी होता. Listed for admission. 30/3/26.
Right.
Yes. 31.
31, my lords, I am appearing for the petitioner. My lords, on last occasion, my learned friend appearing for opposite party praised for time to file objection.
Today I am filing the objection, my lord, serving a copy to my lord.
Sir, you are Mr.
Divyaranjan Bari.
Mr. Divyaranjan Bari for the petitioner, Mr. Ramdas Achari for the opposite party, the learned counsel for the opposite party files objection to the
To the petition. Transfer petition.
To the transfer petition. That was the order.
Objection to the petition. I would have chair. I'll chair. তাহলে এটা সিনে যায় পয়েন্ট নিয়ে যান 31 তো আরম্ভ হয়েছে তো copy of the objection shall be taken on record the court registry file kar copy of the objection taken on record hai
I have already solved the copy.
Copy has already been solved by the learned counsel for the opposite party. Copy of the objection filed by the opposite party has been served by the learned counsel for the petitioner. List in the week commencing 13/4/26.
My lords, interim order was there.
Interim order as passed earlier shall continue till the next date of hearing.
Okay.
Yes, please, next. ঠিক আছে
33.
My lords, item number 33.
Yes, Ms.
I'm on BC, my lords. There is another RFA which has been filed by the respondent wife, opposite party wife. And my lords had directed that both the matters be taken up together. That is RFA number, RPFM number.
I think RFA is not within my determination.
No, pardon, my lords, RPFM. RPFM number.
Acha.
33 of 2016.
Mr. Brindaban Raut for the opposite party. It is stated by the learned counsel.
My lord, in this case, this court director, after appearance of the husband, my lord, the same will be automatically listed in this case, along with this case.
Actually, that is the reason I'm saying that both the matters be taken up.
Specific order.
But the problem is that registry বুঝি পারনান maybe.
My lords, I have already entered appearance. I'm fairly submitting. My learned senior probably is unaware of it.
ସେ ଆପଣ କହିଲା ସେ actually ଜାଣିପାରୁନାହାନ୍ତି ମୁଁ କଣ ଡିକ୍ଟେସନ କଣ ଲେଖିଲେ petitioner that RPFM number କେତେ କହିଲେ 33 of 2025
26 month
2026
yes ma'am
filed by
wife
by the opposite
party
marriage was directed to be listed along with the present RPFM.
Yes.
Stop. The learned counsel for the opposite party submits that the direction was to list both the matters after appearance of the opposite party in the said RPFM.
Yes, ma'am.
Stop. Both the RPFMs, both the petitions, RPFMs for the Olga English. Both the petitions shall be listed in the week commencing.
My responsibility, madam. Wife
ତାଙ୍କୁ ଆଣୁଛନ୍ତି କାହିଁକି କୋର୍ଟ
ସେ ଆସୁଛନ୍ତି ମୁଁ ସାର୍
କରେକ୍ଟ ଆଚ୍ଛା ଠିକ ଅଛି so this RPFM is regarding what
this is
ପିଲାମାନଙ୍କୁ ବି I don't know ପିଲାମାନେ ଯଦି ଭଲ ପାଉଛନ୍ତି ଆସନ୍ତୁ କିଛି ବଟ୍ ପିଲାମାନେ ପିଲାମାନେ ଇନୋସେନ୍ସ ପାଇଁ ବେଳେବେଳେ they don't ମାନେ feel anything bad. But otherwise, ଲୋକମାନେ ଆସିବା ପାଇଁ they get I mean little bit over
strictly ମନା କରୁଛି ଆସିବା
ମାନେ ଠିକ ଅଛି strictly କାହିଁ ମନା କରୁଛନ୍ତି ଆପଣ ଭଳିଆ କଣ ଆପଣ ନେକ୍ସଟ ଜେନେରେସନ ପାଇଁ ଲୟର ବାହାରିବେ ନା ବର୍ତ୍ତମାନ ଯୋଉ ରେଟରେ ଚାଲିବ ବର୍ତ୍ତମାନ yes what is the amount due Mr. Naidu?
My lords, the amount is it has come to 45,000, my lords.
So you convince your client to deposit.
Pardon, my lords.
You ask your client to Katiola.
No,
Then you are getting frozen or you are using off.
No, my lords, I'm present.
I'm sure you are awake and fresh. So
I'm actually not well, but that is the reason. My lords, my lords were saying.
So you ask you tell your client to deposit continue paying if he is paying or if he is in default, then he can make lump sum payment at least for the arrears.
My lords, there is no arrears. I have this honorable court of
Whatever. You see, I am not finding out any fault with anyone. So I am just requesting you that you yourselves verify if any amount is being paid, that should be continued. If not paid, then clear the arrears and continue the. At least
I am paying continuous.
Yes.
My responsibility, 20 near about 28 lakh something is area. As per the direction of this board.
This is not a place for antics.
The new
and dramatics you please confine to the merits. So that is how you help your client.
Yes.
Today morning when you said that that is not your job. Apona 15,000 re pauchanti apona answer hela ha pauchanti. Apona chahuchanti enhancement ki
enhancement to file karchi more
then I am 15,000
enhancement file 15,000
kete chahuchanti.
আমার 40,000 order ହେଇଛି.
Correct, sir. ବର୍ତ୍ତମାନ ଆପଣ investment during this court has directed for payment of 15,000.
Payment of lump sum some amount of area matter till final.
The whole problem is it is not registering. ଆପଣ ହାତ ଫାତ ଦେଖି ବହି ନ ଆଣିକି ଏଇ problem ହବ. We are now not finally hearing the matter.
Yes, ma'am.
Both RPFMs are there at the preliminary bench.
Yes.
Has it registered with you?
Yes.
What is the interim order?
It was 15,000 per month to going to.
So she said that compliant.
Yes.
You said that as far as the original order is concerned, there is a lot of arrear is there. But a court has granted 15,000. So if you want enhancement of that 15,000,
yes, madam.
So you have to file that application?
No.
Document पड़ेला इथरे आगे. आपन को assistance भी कोर्ट दबो सेटा आपन सुनिबेनी. During pendency of a application, what best you can do for your client, apart from telling Dugbari Kahani?
I have filed only vacation of
notice issue instant. Is it something instant over the counter? Apana pizza epote gala sepote baharla. Apana jo jinsa ta kariba katha karantu. Yes, Ms. Naidu, if it is 40,000, 15,000, I will definitely enhance or I will not extend the interim. I will not extend the stay.
I'm paying regularly. And my lords, I'll just point
out. 15,000, 40,000 you carry on paying.
No, my lords, I'll specify. My lords,
40,000 if you are not paying, if you're so okay.
My lords. I'm paying.
I mean, you cannot take advantage of he not taking step.
No, my lords, that is not the point. My lords, this is the second journey.
You plan to pay 40,000 during pendency?
Kindly hear me for a minute. Initially, the amount was 25,000. Then, when this matter was before the slots, this honorable court remitted it back, and the amount was enhanced to 40,000. So that is the reason this honorable court directed to pay 15,000.
Whatever little law I understand, that cannot be the reason for staying of a matter, because it has been enhanced on remand. The first trial.
My lords, we put this tomorrow. I'm ready to argue.
I will not listen. Either you are depositing 40,000 or not. I will not say
40,000. I have to take instructions, my lord. I cannot immediately argue because, my lords, there is nothing for enhancement.
That is on merit. But Rajneesh versus Neha says it is a money decree.
Without the constitution of the client, we cannot take.
Says that any execution has to be disposed of within 1 year. So the execution is pending how much time?
2020.
So the 1 year is complete. So I cannot continue this.
Diligently paying. I'm diligently paying. I have not
skipped a modified amount that I am modifying.
My lords, we put it to tomorrow. I'll come to court. I'm not well, my lords.
I'll record you the.
My lords, we just kindly accommodate for today only because I'm not well. That is
it's not a question of accommodating. I am not today vacating this order. I will modify. I am giving you a hint because he has not filed any petition. He is only arguing antics and dramatics. 25,000 was enhanced to 40,000. 25,000 was challenged by whom?
I had challenged it. And then the matter was remanded back.
Equal to 40,000. So, yes. So 40,000, if you want any, I will not reduce it to 15,000.
My lords has not reduced initially because it was 15,000 was ordered to this court and have continued to pay for the last 5 years.
So that is an interim order that is being modified.
My lords may not put it to 40,000, my lords may say 30,000 at least.
For the appearance.
My lords may just give me one opportunity. I'm not well today. That is the reason I'm praying. My lords may put it to tomorrow.
That opportunity to be given for, not observing that the interim order cannot be continued further. Because today I am not modifying the order. I have told you that I am not modifying the order today. But I'll give reasons why. Yes, that opportunity is being given to you. You are arguing in Congress.
No, my lords. I thought my lords was modifying.
Maybe there is a problem in hearing because most of the sentence.
I may be pardoned, my lords. I'm on 2 courts. That is the reason. My lords, there's another argument where
many of the words you are missing most likely. I never said that modifying today. I said that I will. I'm giving the reasons why I will.
My lords will put it to another. I will satisfy. My lords will.
You have to be patient to hear the court instead of repeating the same 10-15 times.
Pardon, my lords. I apologize.
I apologize for. I have to tell you that I have to dictate the order.
Pardon, my lords.
The petitioner husband is before this court, challenging the order dated
This one 2025.
Just give me a minute. I have to get the file. I appear to be better prepared than you, and I'll take care of your. So don't worry about that.
Yes.
The petitioner husband is before this court challenging the judgment dated 6/1/2025 passed by the Court of Law and Judge Family Court Jajpur. Passed by the Law and Judge Family. You take your seat. Your colleague is sitting. You can sit here also. Passed by the Law and Judge Family Court Jajpur in criminal proceeding number 268 of 2019. Or necklace sentence. Thank you. The said criminal proceeding 268 was filed by the opposite party wife in the marriage. And the minor child, then aged about 1 year, 8 months, seeking maintenance at the rate of petition copy अच्छी आपन पाखे
No, petition to be named.
Linda Jones. So, see monthly maintenance, that's for the wife and dash for the child. The said petition was favored. However, directing payment of a sum of rupees 15,000 per month to the wife and rupees 10,000 for maintenance of the child. Thereafter, RPFM number 300 of 2023 was filed by the husband before this court. The said RPFM was allowed and the matter was remanded by the judgment of this court, by order of this court, by the coordinate bench, by the judgment of this court, dated 16/5/2024, remanding the matter for fresh hearing and determination and decision. Thereafter, the matter has again been adjudicated for coming to the conclusion of forwarding the amount as directed. The following has been stated by the learned Judge Family Court at paragraph 9, 10, 12, 9, 10, 11, 11, 12, 13, 14, 15. Fifteen, 16, 17. The matter was admitted by the coordinate bench by order dated 23/7. Notices were issued by order dated 23/7/2025. However, the amount directed to be paid as maintenance was reduced from 40,000. How much for the wife?
45,000.
That is 25,000 for the wife in the marriage and 15,000 for the child was reduced. Relying on the submissions of was reduced. Reduced.
Enhanced 25 15,000 10,000 थिला.
कौन सोचते आपण 40,000 टा 15,000 हेला एनहांस हेगला. 10,000 for the wife and 5,000 for the child. Perusal of the petition indicates that the perusal of the plaints that is available, as well as the judgment, copy of the judgment that is available, indicates that the petitioner has not disputed that he is working as
a geologist, ONGC members.
He is a geologist working as a geologist in ONGC. The chairman ONGC na ke देखिए the so and so ONGC shall be forwarded copy of this order by the Learned DSGI to give the details of the emoluments received by the petitioner from the date of filing of the petition before the Learned Trial Court. That is 2019. Apparently, for reduction of the amount from 40,000 as directed, taking note of the income of the petitioner, by interim order, this court has to take note of the facts and circumstances regarding income of the petitioner, as the Learned Trial Court has taken note of the salary slip of August 2024 from the drawing and disbursing officer of the petitioner, indicating the salary to be rupee 1,58,407. The petitioner shall also file affidavit giving the details of his income since 2019, which shall indicate his gross pay, deductions, statutory deductions such as income tax, provident fund, etc. Other deductions which are his own volition. From the year 2019 till March 2026. Copy of the petition as well as copy of this order shall be handed over by the registry to the Learned DSGI to do the needful. Para. At this stage, this court takes note of the law laid down by the Honorable Apex Court in Rajneesh versus Deha regarding the maintenance awarded in the proceedings under Section 125 of CRPC. The paragraph would have quote for them. Since effectively, the execution filed by the opposite party has been stayed by interim order dated 23/7/2025. The decision of the larger bench of the Honorable Apex Court in Rahul Shah versus Jinendra, Rahul Shah, so and so is also taken note of, in which the following guidelines have been issued. Yes. How much time to file affidavit, Ms. Naidu?
2 weeks, fellows. 2 weeks.
As paid for by the Learned Counsel for you are the.
May I pray after?
You are opposite party.
Yes, ma'am.
May I pray after 16th of April? After 16th of April.
No, I will direct his personal appearance because if
I'll file the affidavit.
Then if I follow Rajneesh versus Neha, then he has to be detained.
No, my lord, because the lady is also working, and that is the finding also.
So it is contended by the Learned Counsel for the petitioner that since the lady is working, she is not entitled for
No.
the maintenance of rupees 40,000.
That is not my contention.
45,000 towards
That is the only thing.
we are not spending time in gossiping, Ms. Naidu.
My
You
lord,
must
my
understand.
contention
You
is
have said so. I have recorded that.
My lord, she's entitled to, but not. I'm not saying that she's not entitled.
You see, I cannot just brush aside your submissions. They submitted
I admit it.
or like call it. Please.
My lord.
The maintenance awarded by the lauded trial court. The result of the judgment rendered by the lauded trial court indicates that the lauded trial court has taken note of the said aspect. Whether a lady, you take your seat. Whether a lady, if she is working or has capacity to earn, shall be awarded maintenance or not is no more res integra in view of the authoritative pronouncement by the Honorable Apex Court in Rajneesh versus Neha. The Pata court hoga tha. The matter shall be listed in the week commencing. What was the 13 तारीख कहउछन्ते आपण?
No, I guess 16 तारीख, but my lords will put whichever date my lords is submitted. 16 ପରେ ମୁଁ କହୁଛି.
6 4 2026. The affidavit as directed shall be filed by the petitioner by 31/3/2026.
My lords.
The lauded DSGI is requested to obtain the details from the employer of the as directed from the employer of the petitioner as directed above and submit the same along with a memo by 30/3/2026. Yes.
My lords, may I pray that both the matters may come together?
Both
the matters, both the RPFMs may come together, 33 and the present matter.
I don't know why it has not been listed because he says that after notice it may appear.
Appeared. I have appeared, my lords.
That have directed the RPFM kete seta 33 of 2026 filed by you. Yes. The 33 of 2026 shall also be listed on in the week commencing 6/4/2026. Yes.
Oh, bless you.
Yes, next. Yes, next.
35. I'm for the opposite part.
You are Mr. Behra.
Yes, madam. I have filed a
35 petitioner none, Mr. D.K. Behra for the opposite party.
I have already filed a stay vacation petition, ma'am.
Soft copy?
Yes, ma'am.
When did you serve?
25th February, ma'am.
Receipt memo ଅଛି? File କରିଛନ୍ତି?
ସେଥିରେ ମାନେ କପି ରେ ରିସିଭ୍ କରିନି.
Copy receipt କରିଛି.
ବର୍ଷେ ହେଲାଣି ଇଣ୍ଟରଭ୍ୟୁ ମର୍ଡର ଟା କଣ୍ଟିନ୍ୟୁ କରୁଛି.
None appears for the petitioner when the matter is called. Petitioner none, Mr. D.K. Behra, Devendra Kumar Behra for the opposite party. IA number 20 of 2025. Copy of the IA has been served on the learned counsel for the petitioner. Stop. The IA has been filed for IA 61. IA 61 of 2026.
Yes, my lord. IA 61.
61 of 2026. Copy of the IA has been so unlikely. The copy of the IA has been filed for vacation of interim order dated 10/2/2025. Despite service of notice, service of copy of the IA, none appears to oppose the prayer for the prayer made in the IA for vacation of the interim order. To grant further opportunity to the petitioner in the petition, the matter shall be listed for orders. In the week commence,
Next week.
The week commencing 23.
Yes.
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 36.
Mr. Sahoo, B. Sahoo, Pramukh Sahoo for the petitioner. Mr. P. Das for the opposite party. Yes. You agree for a particular place for prosecuting the matter? What is the petition? TRPC?
I am the married wife, married residing at Sambalpur. Now the married due to disturbance, married left the matrimonial place, and there is a dispute between the husband and wife for which a affair has been lost at Sambalpur. Thereafter, he is staying is the elder father's house. Now the situation, he is continuing his computer training regarding getting a better service, because the wife resided at
It is section 24 argue করছেন না কোন TRPC section 24 argue করন্তু computer training কোন argue করছেন
না না, ସେ computer training ନବା ପାଇଁ ଆସିଲା ଏଠି ଇଏ କରିବ ଚାକିରି କରିବ ବୋଲି। Now the present petitioner studying at Sambalpur University, I will file affidavit regarding to that effect. Let keep it a short date, my lord.
I could not get you. Study of the petitioner wife is a factor for transferring the matter from Devagad to Sambalpur.
Well, that is the matter income.
Show some precedence.
Paramount consideration.
So which is the decision? Paramount I have been searching. The paramount consideration regarding study of the convenience of the lady. So that I have to, you have to tell me that on the facts decision I am still searching. You also work on that if there is any such decision.
My lord, may I submit? This is my lord, 5 to 6 times this matter was listed previously, and a stay order has been passed by this honorable court since 7/3/25. So my submission, this is a case where the husband has filed the 13A petition before where the residence of wife situated. Husband has not filed the petition in his place or at the matrimonial place. Husband has filed the petition at
Section 19(3). Or see what is that?
My lord.
Section 19 you are saying.
So my lord, on the face of the record, my lord, it is for the convenience of the wife, so that the husband would never wanted to see this situation. But husband is suffering since 1 year, despite filing the petition before the court. The lady.
Sir, in every matter, whenever somebody comes to me, I grant that stay.
That
notice and I interfere in the process before the trial court.
My lord, my lord.
What can be done?
My lord, my only submission is
so for that reason now you have taken also. Now I understand. Since the matrimonial suit, usually the plea is that the suit should be at my place, wife place. Since it is at wife place,
yes,
you are saying that it should be at the place of the education place.
Education place.
How it can be? How it can be? My lord, what you will do?
1 week time दियंतु आगे हमको देखियो कौन
for 10 maybe, but you must understand that if the petition is filed at the place of residence of the wife, it is registered. It has to go to the place of study. So why may not go to London for further studies? Suppose now I really like you, I give that reason. And nowadays every day somebody is studying in for foreign studies. I mean, may not be now they are living out some other reason for USA, but so many people are going to UK. Then what would be my logic? I have to say that because the trial has to continue at the place, or I'll ask the university to fail the wife so that she continues for the eternity. What she is studying there?
Business administration.
She will not pass. MBA is a 2-year course.
So 2026 रे से admission नहीं चाहिए. That is my I got telephonic information.
So for that it has to be at Sambalpur. You ask your client also to study MBA or MCA or LLB.
He is a contractor, my lord. I am
yes, he can study, so that is easier for him.
2022, my lord, I am not getting a single pie, my lord.
The getting single pie, like Mr. Raut was arguing, you have to file application, file execution, file petition in 24. But you have stalled to the 13 petition. Did you file 24 in section 13 petition? You are chopping up the branch where you are sitting. Where you can get section 24 pendant like maintenance from the contractor husband, you have got a stay from this court. And obviously, when you ask the court that also please, as far as 24 is concerned, please don't stay.
No,
but section 13.
No, your
So that cannot be bifurcated.
No, I think, my lord, your lordship keep it short date, my lord.
Lordship, if
Mr. Brahmakesh Sahoo for the no, I understand this will not make much headway. Better to close the hearing for the day immediately. Because this is another novel concept that where the wife studies. Mr. Brahmakesh Sahoo for the petitioner. Mr. Prabin Das for the, both of you take your seat, I'll dictate that. So Prabin Das for the opposite party. And at times problem is that Mr. Das, the might of money also is dictating the terms with the court. May not be in this case. The answer is that I will not pay. I don't know if you would have paid something, then should have been.
No application has been filed.
I understand.
No order has been passed.
I understand that Mr. Sahoo, you must have, you should have looked at his face. When I asked him that which application you have filed, you should have looked at him. Or you can see in the video. He's a smart guy. The wife in the marriage is before this court, seeking transfer of the CP number 3 of 2025 from the Court of the Learned Judge Family Court Devgarh to the Court of the Learned Judge Family Court Sambalpur. The application under the present application under section 24 of the CPC was filed in the year 2025 on 17/2/2025. से कौन डिस्टर्ब अपन जो कहले डिस्टर्बेंस है कि से कौन सिर्फ में पढ़े चाहिए ना कौन डिस्टर्बेंस है लेवल एमबीए करूछन.
No, lordship, my lord.
That if I start writing, actually, I don't know where I will end up. Anyway, you sit down. कौन लिख ले? हाँ, year no kari on itte kar dele before this court. The CP was filed by the husband in the marriage before the learned judge Family Court Devgarh in January 2025. The pleadings of the petitioner wife reveal that the marriage was solemnized at Devgarh on 23/1/2022. The petitioner wife also belongs to Devgarh, where the suit has been filed, where the CP has been filed. See, Rautile Kuti?
Malot at Devgarh. She has
the both the parties.
No, my lord. I'm sorry, my lord. Both the parties were staying at Hon'Ble because the husband
places at Hon'Ble. Staying at Hon'Ble after marriage, having that matrimonial home. It is submitted by the learned counsel for the petitioner that in the year 2026, the petitioner has taken admission in MBA course in Sambalpur University. In Sambalpur University at Sambalpur, for which the petition should be transferred from Devgarh to Sambalpur. The learned counsel for the opposite party refers to the section 19 of the Hindu Marriage Act, which provides for the territorial jurisdiction of the court to entertain the petition under the said act. Section 19 is reproduced herein. It is submitted by the learned counsel for the opposite party that conditions specified in section 19 that is 1 as well as 3-a are satisfied. Therefore, the petition should not be transferred where the petitioner, where the opposite party wife chooses to undertake her studies. The learned counsel for the petitioner seeks and has adjourned. List in the week commencing. List for further hearing in the week commencing. 13/4/2026.
Any shorter date if I only
plus the data part the most important part actually. The learned counsel for the petitioner submits that the petitioner is not getting any income maintenance during pendency of the CP. The learned counsel for the learned counsel was asked whether any petition has been filed before any court or any petition under the Hindu Marriage Act has been filed seeking maintenance. It is in response, it is submitted that the petitioner has not filed any application and the proceeding before the United Court at Devgarh has been stayed by this court. So that's actually this shorter adjournments actually is not working. That is how in many high courts they give 6 months so that at least matters are accommodated.
Interim order.
24 फाइल करी नो नाहंती तो इंटरिम ऑर्डर के नोचंती 24 टा सीटी फाइल करथिले आपण किछि पाई थांते आपण बर्तमान एमबीए पर एमसीए करिवे आ लॉ करिवे तो आउट जब शिफ्ट करे पड़िबो. If I extend this logic that wherever the wife studies, decides to study, that should be the place of litigation. Must understand that. Only interim order as passed earlier shall continue till the next date of hearing.
57, the wife is before your lordship seeking transfer of the civil proceeding filed by my husband from Judge Family Court Puri to the learned Judge Family Court Bhubaneswar.
So actually you agree for a place? That would be better.
Without recording any concession, lordship?
No, definitely. No.
Because another...
Any matter in Bhubaneswar has to go to Mr. Achari.
No, that is not the case. CRP, because CRP is pending.
CRP is pending.
That 125 proceeding is pending in
Bhubaneswar. He is also contesting the check.
That is the...
Obviously.
Lordship.
Our CP actually...
also going to Puri.
Lordship?
Are you appearing in Puri or Bhubaneswar?
Bhubaneswar.
Sir, the Mr. Chakravarti knows that. That is how he is saying Bhubaneswar.
ନାଇଁ ଅଫିସ ଅନ୍ୟମାନେ ଫାଇଲ କରିଛନ୍ତି ମୁଁ ଭୁବନେଶ୍ୱର
ଆପଣ ତ ଏଠି ହାଇକୋର୍ଟ ବି ଆସିପାରୁନାହାନ୍ତି ଆପଣ ଏତେ ବ୍ୟସ୍ତ ରହୁଛନ୍ତି
ନାଇଁ
ଆସୁଛନ୍ତି ଏଠି ଆସୁନାହାନ୍ତି
sorry that on last 2 occasions I could not appear.
Exactly.
Sorry.
No, why should you say sorry, sir? That shows that the signs of prosperity.
Not keeping...
Nobody should complain, sir.
No, not keeping well, that is why. Otherwise,
take care of your health also.
Otherwise, I enjoy to appear with your loss.
Both of you take your seat. I'll dictate that. I'll take some time. Mr. S. Chakravarti, the petitioner, Mr. Ramdas Achari, the opposite party. The petitioner wife is before this court seeking transfer of the CP number 76 of 2024. Pending before the Learned Judge, Family Court, Puri, to the court of Learned Judge, to the court of Learned, to the family court at Bhubaneswar.
Family Court 2.
नहीं 1 2 ସେମାନେ
Family Court main टा family court 2 टा ହେଲା
ये चाହୁଛନ୍ତି कोठी 2 मिस्टर आचार्य डिसाइड करबे ना ना सेटा ताको छै
2 रे अछि criminal
सीआरपी टा तांकर
आपण जोडी चाहिबे सेठी हबो
नहीं तांकर से 2 रे पेंडिंग अछि
आपण कोन 2 ना 1 चाहुଛନ୍ତି
2 हो गोटे जगह रे चलले भल तांको पे भी करने
2 at Bhubaneswar. The CP was filed. The CP has been filed by the husband in the marriage. Under section 13 into bracket 1, bracket I dash small a into bracket I dash small b, then Roman 3 of Hindu Marriage Act. Is 18 years. Seeking dissolution of the marriage solemnized between the parties on 25/2010 at village Barodiha, Paradiha, the district of Khurda. The matrimonial home of the parties to the litigation is at village Narsingpur Hat, district Puri. Pursuant to the notices issued by this court by order dated 16/25, the opposite party husband has entered appearance. Thereafter, thereafter, stop. The hard learned counsel for the parties at length. Supporting the prayer for transfer, the learned counsel for the petitioner, Mr. Chakraborty, submits that the petitioner, after the petitioner wife, after her marriage has gone into rough weather, stays with her parents at Balipatana, near Bhubaneswar in the district of Khurda. What 125 na 498 file question?
125.
The section, the petition under section 125 of CRPC, that is CRP number 147 of 2024, filed by the wife seeking monthly maintenance, is pending before the Learned Judge, Family Court, Dash Roman 2, Bhubaneswar. It is submitted that in the interest of justice and fair play, both the matters should be taken up together. The learned counsel for the petitioner also highlights the fact that the distance of the courts at Puri and at Bhubaneswar is not that much, and the village of the ଆପଣଙ୍କ workplace ନା ଆପଣଙ୍କର କଣ ମିଷ୍ଟର ଆଚାର୍ଯ୍ୟ ଆପଣ ରହୁଛନ୍ତି ପୁରୀରେ ନା ସେ ଯୋଉ village ନିଆଳିରେ
ଆଜ୍ଞା
the workplace of the এটা workplace ନା କଣ ସେଟା place of avocation
yes
କଣ କରନ୍ତି ସେ
କଣ ତ ଜାଣିନି
କଣ ଜୁନିୟର ତାଙ୍କ ଜୁନିୟର ଉପରେ ଆପଣ ଜାଣିଛନ୍ତି ଦେଖା ବି ଆପଣ କରୁନାହାନ୍ତି।
ସେ ଲେଖିଛନ୍ତି ଡେଲି ଲେବରର କିନ୍ତୁ
କିଛି କରିନି ବୋଲି ସେ କହିଲା।
125 ରେ ଆପଣ କ୍ଲିକ୍ ପ୍ରପର ତ ଥିବ ଆଉ।
ନାଇଁ ଡେଲି ୱେଜ୍ ଏର୍ନର ବୋଲି ସେ କହୁଥିଲେ କିନ୍ତୁ ଏକ୍ସାକ୍ଟ
When you get married, you see the video, then you realize how the couple gets married in Hindu marriage.
ରାସ୍ତାରେ ଚାଲି ହଉନି ବାହାଘର
ବାସ୍ନାରେ ନା ନାଇଁ ଏଥିରେ
ବାସ୍ନା ବାଣ ସବୁ ଭିଡ
ବାଣରେ ତ ବନ୍ଦ ହେଇଗଲା ବାସ୍ନା ବନ୍ଦ ହେଇପାରିଲା। Chakraborty, this is serious. I was told by my teacher when I because I am a Stein student, so I was completely out of place in understanding the niceties of law. When he said that will I mean essentials of Hindu marriage is that vasna hava.
बिना
Saptapadi, and Hastavanthi and apart from that
ଆଗ ବରଯାତ୍ରୀ ଗଲେ ତ ବାହା ହବ ନା।
Sir, recently I was told by a very responsible, because I can't that much, beyond that I cannot say, that he was threatened by all the Bharatis. Very objected that why there is so much of smell. He said that you have not invited us, your brother has invited us. Now the person who told me, he is now 61. Of course, I mean it is a long old story. So that is very important also. So that is how in 50s also I think it should have been the essential ingredient that was told by our teacher. My teacher who told he was practicing also. then practice was permitted by law teachers. So Arun Kumar, I mean their teachings actually what we are today, our teachers. So कौन देख लो and the present place of residence is at Nearly, which is nearer to the court at Khordha. Scholarly counsel for the opposite party opposes the prayer for transfer of the matter. He submits that Section 19 of the Hindu Marriage Act, read with Section 9 of CPC, would indicate that the place of prosecution of the CP is correct. The Learned Judge Family Court Puri, having the territorial jurisdiction. Para. Having had learned counsel for the parties and taking note of the fact, having had learned counsel for the parties as well as considering the material on record, it is directed that in the interest of justice and equity, the CP number 76 of 2024, presently before the Learned Judge Family Court Puri, shall be transferred to the Court of the Learned Judge Family Court -2, Bhubaneswar. The same CP shall also be taken up along with total CRP টা 174 নাকি 140 147 of 2024, filed by the wife, now pending before the Learned Judge Family Court -2. It is further directed that the parties to the litigation, the parties to the proceeding, not litigation, to the proceeding shall sincerely proceed with the matter, cooperate with the Learned Court for expeditious disposal. As by transferring the proceeding, which is pending since 2024, now becomes a proceeding of the year 2026 before the Learned Judge Family Court, Bhubaneswar, Family Court 2, Family Court -2, Bhubaneswar. The petition is allowed with the aforesaid observations. Yes, Mr. This court puts on record the its appreciation for both the learned counsel for the parties in a pending matter where the cause of action arises in the year 2024 and the process of stalled due to pendency of this application. The parties, the copy of this order shall be forwarded to the copy of the judgment record. A copy of this judgment shall be forwarded to the learned court Puri, as well as the learned court US Family Court 2. So Puri likhe to be kept in the records of so and so so and so.
Puri pathebe record.
Correct. The records shall be accordingly sent to the office of the Learned Judge Family Court -2 at Bhubaneswar. The parties agree କରନ୍ତୁ ଗୋଟେ date agree କରନ୍ତୁ appear କରିବି.
Next 1 week after that.
Puri record ଟା ଆସିଲା ପରେ ତ
the parties shall appear before the Learned Judge Family Court. ଆପଣ କେବେ ଫ୍ରି ରହୁଛନ୍ତି ଦେଖୁନାହାନ୍ତି ସେଇଦିନ appear ଆପଣ ଯିବେନି ଆଉ ସେଠି ଯାଇ ଆଉ ଯିବେନି. The Family Court to Puri on
Puri Bhubaneswar.
Sorry, Family Court to Bhubaneswar on 30 on 30/2026. On the said date, the Learned Court shall do well to fix a date for further proceeding of the matter. But it is notice stage re stay होइथिबो.
Notice हम पाइछ. हमें
appeal consideration हेनी.
नहीं. Only one line. By stating the order, Lordship has said that the place of residence of the opposite party nearly the place at Bhubaneswar.
Nearer to Bhubaneswar. ସେଟା ଗୋଟେ ଖୋର୍ଦ୍ଧା ଗୋଟେ ଜାଗା
ସେଟା ମାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ପ୍ରୋବ୍ଲେମ ହବ. I am getting confused.
Sorry.
ଆପଣ ବର୍ତ୍ତମାନ ଆଜି latest proposition I have to think because I try to understand also because it observes actually and it's a good thing. The place of is where the is. Section 19 में सेट आसो सेटा. Section 24 रे कहले जे convenience of the parties. सेटा को हमर इंटरप्रिटेशन आपण कहले जे अछि जे convenience of the wife lady. This is very confusing actually. So that struggle still continues. They said to understand the concepts. And good thing is that our profession is once a student of law, always a student of law. Best part. The rest of the matters being in the hearing nature, we'll let us start.
Act of 40 military model is there. Maybe tomorrow, one.
40 not possible, madam. I understand, but
Now the outstanding is 25 lakhs. So Gariba
execution କରନ୍ତୁ. ଆପଣ execution କରନ୍ତୁ. ବର୍ତ୍ତମାନ ସବୁ ଜାଣି
execution stay ହେଇଛି. Execution stay. You have paid to the financer. Your lordship one day मतलब काली
ସେମିତି କରନ୍ତୁନି. ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ବହୁତ ଅଛି. ଆପଣ ପଇସା
25 ଲକ୍ଷ ଟଙ୍କା ସେ କେମିତି ପେମେଣ୍ଟ କରିବ?
ଜେନେରାଲ ତୁମକୁ ହେଇପାରିବନି. ଆପଣ ନୋଟିସ୍ କେମିତି ହବ?
ଛୋଟ ମ୍ୟାଟର ଟା କିଛି ନାହିଁ ଏଥିରେ.
ମୁଁ ତ ବୁଝିପାରୁନି.
ମାନେ ଟୁମୋର
ସେଇଟା
25 lakhs ସେ ପେମେଣ୍ଟ କରିପାରିବନି.
କରିଦେବେ ଆପଣ 24/4 ନା କେତେ? ୱିକ୍ କମେନ୍ସିଂ 24/4 13/4.
My lord, this March, in the month of March.
नहीं.
My lord, in the month of March.
Actually, you are in the anxiety, you are losing the track. Month of March से आपनकर 86 85 48. This is the statistics. When you see there is no difficulty in listing 100 matters also, but depending on the assignment, you have to hear the matters or not. So obviously it will take some time. And in matrimonial matters, obviously it will take time. So gradually the things will, as you call that, you score few runs. So gradually the things will be taken care of. Instantly it will not happen. There is already dependency and the nature of adjudication is, so many cases.
Outstanding बढ़ुची से इतना ही more request करूँगी.
ସେଇଟା outstanding बढ़िଲେ ସେଇଟା ତ court ପାଇଁ बढ़ुନି.
I see a
file କଲେ ଆଜ୍ଞା ସବୁ ଯଦି ହେଇଯାଇଥାନ୍ତା ତାହେଲେ ତ open and short. जो दिन केस फाइल हम दिन पैसा देवे जो दिन केस फाइल हम ट्रांसफर हो सेमती तो दैट्स नॉट आंसर एक्चुअली दैट्स ए योर कंसर्न इज करेक्ट कंसर्न एब्सोल्युटली राइट बट नेवर आइडेंटिफाई योरसेल्फ पर्सनली विथ एनी केस आपण दिस मैटर ना जो आपण कहले जे कॉपी नेबिले बोली
Fine.
That
is fact. That is fact.
अरे ठीक है
also.
ठीक है अपन तो डिस्टर्ब काहे होचंती
ଆପଣ ମୁଁ ମିଛ କହିବିନି
ସେମିତି ହୁଏ ଆଜ୍ଞା ଛଡେଇକି ନେଇଯିବେ ସେଟା ହେଇଛି ଆଗରୁ
ନେଇଛନ୍ତି ମ୍ୟାଡମ
ସେଟା କହୁଛନ୍ତି ଆପଣ ସେ ବ୍ୟସ୍ତ ସେମିତି ଡୋଣ୍ଟ ବି ଦ୍ୟାଟ ଏତେ ଆଂଜାଇଟି ହେଲେ ଆପଣଙ୍କର ପ୍ରଫେସନ ଇମ୍ପାକ୍ଟେଡ ହେଇଯିବ
ନାଇଁ
ବିକଜ ହେଲ୍ଥ ଇଜ ୱେଲ୍ଥ ଆପଣ ସେଟା ଯାହା ବ୍ୟସ୍ତ ହେଲେ ଆପଣ ସେଦିନ
suffering, the client is suffering. I do understand. That is the reason.
फाइनांस कंपनी सफर करेନି फाइनांस कंपनी कौन सफर करियो
नहीं ये हूँ client means the lady.
सी कौन लोन लेते
Complainant has to purchase insurance. Yes.
ट्रक चलो ना
repossessed. Truck भी नहीं गले. Outstanding.
रिपोजिशन है
ना accident met with an accident. Insurance company has insurance company. The financial man.
ठीक अछि डोंट बी एते आपण माने ये रीड बोलतुनी आपणकर आई वाज रियली माने
जते मार्च रे
कंसर्न रिगार्डिंग आपण जते व्यस्त से रहउतले
मार्च रे हितिले
मार्च रे आपणकर 85 टा 84 85 ऑलरेडी मैटर अछि ता भीतर छुट्टी अछि यू मस्ट अंडरस्टैंड एक्चुअली इट इज अ मोर प्रैक्टिकल अप्रोच दैट यू डिस्ट्रीब्यूट द मैटर्स एंड इफ यू सी अदर हाई कोर्ट्स 15 दिन मासे रे के डेट दो नांती many high courts 6 months is the standard form because after hearing matters can at least be taken up spread over
as you wish.
Yes please
status quo maybe matter
no it has not been touched chhad diyo once the time is over up yes Mr. Sahoo
item 38 is short date man
yes my lord
particular date he pariyo short date he pariyo
I am there for item number 38 for the petitioner.
You take a date, Mr. Sahoo is suggesting, requesting for a date.
My lord.
You will date kariye kod diyo. We commencing 13/4 portion.
Agya. Grateful lordship.